Well, these are the revised written submissions. Were already uploaded matter prior to the starting of the arguments. Now, these are the revised written submissions.
Fix the mic properly and then start.
Your Lordship, please, my lord. Your Lordship can straightway come to the page number 8 of my written submissions. Because on certain points, I want to make some clarification. I'm on behalf of the original writ petitioner, Indian Young Lawyers Association.
So light, how does it make any difference?
Kindly see page 8. This is very important how this PIL has come up. Case history, paragraph 1. There were 4 annexures, 4 articles rather, in the newspaper. In the month of the June 2006, kindly see, one was of the Barkhadat, scent of women. Then there was touching faith, an actress touches a deity and causes an uproar by Sherwani Pandit. Then the third was keeping the faith, losing our religion. This was the third by Veer Sangvi. And the fourth one is very important, is the sex slur fells Sabrimala. Because there was some news item which I have already annexed to these written submissions also. This was also the part of the writ petition, annexure 4. I have also annexed to these written submissions also, where there was an allegation that the priest has been found in the brothel with the prostitute. So this was the allegation again on this issue. I have annexed that particular news item.
Counsel, what is it? Please come to the issue. We have been hearing them at length. We are hearing you at length. Come to the issue.
I'm coming to the issue, but there is some problem. The problem here is this. Every time this is being alleged, as if I am challenging the faith of other. I'm not challenging. Therefore, I have to bring into your Lordship's notice the prayer which we have made. We have quoted the prayer. Kindly see the prayer.
Yes.
Kindly see page 9.
Yes.
I will not take much time, my lord, but certain facts are to be clarified. Page 9. See my prayer A. Issue any appropriate writ or direction commanding the government of Kerala, Devasam Board of Travancore, Chief Tantri of Sabrimala, the district magistrate of this, and their officers to ensure entry of female devotees between the age group of 10 to 50 at the Lord Ayappa temple at Sabrimala, Kerala, which has been denied to them on the basis of certain anti-Hindu, ill-conceived Hindu custom or uses, as reported in certain newspapers, including an article written by such and such. Then, and consequently, in the middle of this.
So we understand your entire petition was based upon certain news items.
News item. This was the news item.
Next.
And which has attracted certain lawyers.
The rules also, like others, which have the rules also.
So it has attracted certain lawyers here.
And prayer B then is out question of the rules.
Yes.
Now, kindly see, the main thing is this is the entire area of prayers. I am not challenging any faith. Rather, I have reposed the faith. Therefore, we are seeking the entry. Suppose if we want to enter into any temple, why we are entering into the temple? Only in order to repose
You
the faith.
understood. How do you reconcile prayer A with para 3 on page 10?
Prayer A?
Your prayer A, how do you reconcile with para 3 on page 10?
Affidavit.
No, para 3 on page 10.
So according to you,
Issue prayer C.
Prayer A.
Yes.
Prayer A is to allow the women in the age group of 10 to 50
10 to 50.
to enter the temple.
And temple.
This is what you are asking. You are asking the state government, board, and every authority a direction that they must ensure the entry.
I am obliged.
Now, in para 3, you say you did not challenge the faith, belief. How do you reconcile with two prayers, the prayer A and para 3?
according to the belief is to allow the women.
So we
Belief is to allow the women, that has been changed. So for that, the original belief should be restored.
No, I am explaining what is the belief.
What we're saying,
Ah.
the belief is
I'll-
procurement should be allowed.
Just I'm explaining the
That's
subsequent
all. We
paragraph.
got it, we
Please.
understand.
Just 1 minute, my lord. I'm obliged to your lordships, my lord. Paragraph 3. What is the belief? Can we see that I have taken out the belief out of the judgment of the Kerala High Court that is reported in AIR 1993 Kerala 42. I have quoted the extract of it.
Yes.
Page 10. I'm just reading.
How
The
does,
country of
how
the
does a
temple-
juristic body, how does a juristic body, which is your association, have belief?
No, I'm not saying it's the
Juristic
belief.
body
No,
cannot
how-
be
how-
having a
how
belief.
anybody
It's
can-
only for a human being,
Malala, first
an
thing,
individual who can have belief,
I may just
have conscience.
I will come to first
So who
see
is
what
the
is the
pres-
belief.
Mr.
What is the
Counsel, who
belief?
is the president of this association?
Yes.
Pardon?
Who is the president of this association?
President is Naushad Ali. And there was a lot of.
So
controversy.
there,
How is a believer?
Just 1 minute. I'm telling every explanation.
we want to
Everything
know
is there
from
in
you.
the written submissions. But your lordship may just allow me to just pass on certain pages. Every question
All right,
which your
all right,
lordship is
proceed-
saying
proceed
is
further.
explained in this written submission.
Unless you satisfy
Just
us
hear
that
me.
the juristic entity has conscience.
Just bear me. Just bear me. Only for a few minutes, just bear me. It will come. Your ladyship's answer is there. Kindly see what is the belief. How the belief has been found in the Kerala High Court. That I am quoting the judgment of your lordship. Kindly see, my lord. It's very important.
Juristic entity.
The Tantri, your lordship got it? At page 10, bottom, the judgment of the Kerala High Court. The Tantri of the temple Shri Maheshwararu had mentioned about the Deva Prasannam conducted at Sabrimala by astrologers in exhibit C2. He had mentioned in that reply that in the Deva Prasannams, it was revealed that young women should not be permitted to worship at the temple. There was no such custom as something like that uses. Then further, the report of the Deva Prasannam conducted in 1985, can you see? Next page. From 5/4/1985, it is not very old, to 8/4/1985 was exhibited as exhibit clause. That is a Deva Prasannam publication, which was filed there before the Honorable High Court, the authenticity of which is not in dispute. The English translation of the relevant portion contained at page 7 of the original report reads as follows. It is seen that the deity does not like young ladies entering the precincts of the temple. This is the belief.
All right.
Okay.
What has been fought by the Kerala High Court? Is it in regard of the Lord Ayappa, or it is the insult of the Lord Ayappa? That the deity does not like the young ladies. This is not the belief. This could never be the belief.
Are you,
Your belief is like this.
how are you concerned with all this? If you tell us.
Well, I am concerned, I am a weaver.
Concerned
Are
with
you
all
the chief
this.
priest of the country?
How are you concerned?
Kindly see, my lord. I am,
Yes,
firstly, I'm also answered subsequently.
mind your business.
But I am coming to that particular point also. I am first a woman,
Young lawyer,
then I am a Hindu, then I am any other thing. First I am a woman. And my womanhood has been attacked.
what is
And you say from your own side you are putting certain words into the mouth of the Lord Ayappa.
We understood your
That the
argument.
Lord Ayappa does not like the young ladies.
Indian Young Lawyers
Kindly see.
Association has no other business? They can't work for the welfare of the bar or
Mother.
assist the bench
Mother.
or the legal system of this country
Mother, there are
other
so,
than doing this kind of work?
Mother, there are so many PILs
Yes,
that are
yes.
filed by the lawyers and have been admitted. And in this
One
particular
second.
case, I will come to this
Mr.
conclusion.
Work for
Counsel,
bar, work for younger members, work for their welfare. Those who are struggling in the country from rural areas, they have difficulty coming to the cities to argue cases. They are brilliant minds. People who have come from the villages,
See you later.
brilliant minds.
Your
They have
lordship.
no wherewithal. Work for them rather than doing this kind in the Supreme Court.
Mr. Counsel, your association has passed a resolution
Not only association.
No,
there are five
authorizing filing of a PIL,
But
and whether the president is a
yeah,
signatory to this.
this is not only an association.
So we are asking you on facts,
There are 5 other individual women lawyers also.
no, whether a resolution has been passed by the association.
All these questions, my lord, I will come to this particular point. When Chief Justice Deepak Mishra has refused to withdraw this petition, when there was a threat to the writ petitioner, the threat was to the Naushad Ali. Police protection was given by this
Yes,
honorable court
All right, all right.
to the petitioners also and to me also. They were the threat to the council also. Then the police protection was given.
You are not-
I have an exact order of
Not
this honorable.
to answer the question posed by us. We are simply asking whether a resolution was passed.
No.
If so, whether the president is a signatory to this
No,
association.
it does not.
If so,
No,
what
it is
is
a
his
court.
locus?
Malad, the Justice Deepak Mishra has made it very clear, now it is a court matter. And even if the president of the association tries to withdraw this writ petition, I will not allow.
Mr.
That
Gupta,
is mentioned.
Mr. Gupta, first don't mention individual names of the judges. The honorable judge was not only, he remained judge of this court, he remained Chief Justice of India. So you will talk that the Supreme Court, these and Supreme Court observed like this, these and Supreme Court have like, don't attribute to individual judges, number one. Number two, the question is very simple to you. It's not a very complicated legal issue. That did the association pass any resolution?
No.
But even before
I-
my
to
brother
my-
asked,
To my
before you-
knowledge, it was not.
was there any association? How an association is formed in India?
My knowledge, there is no such a resolution.
Are you
If
a
there is there,
registered body?
I will ask for it.
Are you a registered body?
You are not.
I'm a registered body. No. It is a registered body. Otherwise, I could not have filed it, madam. It is a registered body of the lawyers of this court.
Perfectly.
The
Anna.
welfare of young lawyers.
Most of them are women, lawyers. They are the members of this association. But there are males also. Unfortunately or fortunately, whatever you
Don't embarrass and expose yourself and embarrass the court. By taking up with costly causes like this.
Yes.
They can't say anything beyond this. And that it's a clear case of abuse of process of law. Exhibited the council before before the 9 judges bench. We are very, very sorry to say this.
Having devastating
We are hearing
consequences on
illuminating argument from both sides.
Kindly see.
And then
Kindly see, because
see, now a petition like this.
one of the issue,
it
that is the
causes
issue
so
number
much of
7.
discomfort.
One of the issue number 7 relates to this. Whether such an kind
We will,
of
we will
could be admitted or not.
without
Kindly
going
see
to
the
touch
judgment
upon
of
the question of law.
Mishra, what he has stated about.
All right, now tell us what you want to say on the 7 issues frame. We will not, at least now we don't want to expose, embarrass you. Please go into the legal issue and then make your submission. To that extent, still we are reasonable to enough to hear you. Please tell us on the issues frame. We already said, listen, we already said
I'm coming. I have to address.
both sides are,
I have to address the issues.
listen to us.
Provided the
Why
reference
don't you listen
order,
to us?
provided.
Why don't you listen to us?
Well, just a minute.
Listen, 1 minute. Both sides have agreed more than once, even at the start of beginning, that we will not address the issues of fact, because that will be decided at a later point of time. We are addressing purely on the questions of law. You have said it, please go into the questions of law. That's what we are asking you. If you have nothing else to offer, say it, then we'll go to the next person.
Yes.
Please. Hopefully you understand what we are saying.
Well, I will, since the issue number 7 was there, I have addressed.
Yes.
There is an order of the Chief Justice Deepak Mishra that this cannot be withdrawn by the president because of the threat. This PIL we will not allow. That order I have already annexed with the written submissions.
Perfectly fine.
So now it is a court matter. He has very categorically stated this is a court matter now.
We want to know why you filed this PIL at all. What was it that you wanted to achieve?
No, Malad, during the course of
There
the
must-
argument
there
before the
must-
constitution bench, before the division,
Out of it.
Malad,
What
these,
good has come out of it?
these issues were raised at the time of the admission of the writ petition. It was before the 2 judges bench, then it was referred to the 3 judges bench, then it was referred to the constitution bench, now it is before the 9 judges bench. So it has taken a long distance, it has traveled a long distance, my lord. And now at the apex level, before the 9 judges bench, if your lordship is asking one issue which is related to the division bench, at that moment, at the time of the maintainability of the writ petition. So, my lord, therefore I am addressing, kindly see, my lord, one by one, just allow me, my lord.
Please
Just
go
please
in.
allow.
No problem, that's what we are also telling you.
Kindly see.
Yes.
I will. Just a moment. Now kindly see next page. At page 12, then the notice was issued. And after the Kerala High Court judgment, I've already stated that what the belief was. The belief was to the exclusion of others. Then kindly see page 14. Lord Ayappa was a Buddhist. And it has been admitted by the state of
You are
Kerala.
saying you are a believer and you are saying you are having faith. And now you say, no, Lord Ayappa himself was someone else. Sir.
I'm just
What is this, sir?
kindly bear with me for some time, because this is what the state of Kerala has.
We are not telling
The state
you.
of Kerala has said.
What is your belief? We want to know, not what state of
No, I
Kerala is
believe
saying.
I will not enter into any temple unless I don't have the belief. For example, just 4 kilometers from here, there is a temple of the Lord Hanuman, where you have to offer a bottle of drinks. I don't know
Your
whether your
belief
lordship
is
has heard
not the
about it or
court's
not.
belief, that the court is
So I do not enter
It's belief for
because
belief
I
for the
don't
petition.
believe in it. I don't want to offer a bottle of drink to the Lord Hanuman. So I will not enter. Suppose if I enter into the temple and say, what you are doing it, I will not allow you. Then your lordship can say, once I am entering into a temple or in a masjid or in a church, we have to follow the norms. So far the faith is concerned, belief, I am saying, the belief, what has been extracted in the judgment of the division bench of the Kerala High Court, and that after research, they have said that Lord Ayappa does not like young ladies. This could not be the belief, to the exclusion of others. Now kindly see next thereafter. So far as the Buddhist connection is there, that the great Tang records of the Western regions by Huan Sang, in his book, it was mentioned about the Lord, about this Lord Ayappa, which they used to call him Alokeshwara. Then, my lord, I have given this brief description of the Lord Ayappa, the life. I know your lordship must be knowing about it, because it was believed that he is born out of the Lord Shiva and Vishnu as a Mohini. And this boy was found at the bank of the Pampa River. There was a king. So king took him to, because he had no child, and he brought him up. At the age of the 12 years near about, the king thought that he will become the king. In order to stop him from succeeding to the kingdom, she said that there was some relative or something like that I will like to make him. So she instigated the king, however, to oust Lord Ayappa from the house. And she succeeded. And she said that she found that I am ill and I need the milk of the tiger. So ask this child to go to the forest and bring that milk of the tiger. It is a forest reserve.
Gupta, they are not hearing you on merit. We already said that.
Well,
You reserve everything. When after we answer the question, please, now we are also running short of time. Honorable Chief Justice, His Grace is enough to extend the time from time to time, only on the promise that everybody should be heard. You are eating into the time of your own colleagues.
I will finish
Please,
before lunch.
here you no problem. Please go into the legal issue. Once
Then
again, we are telling you, please go into the 7 issues raised.
I am coming, my lord.
Don't, you are not even coming.
I am coming to those issues. Kindly have.
You say you are coming, you are standing there itself, that's a problem.
That you are not coming.
Kindly,
Please come.
kindly see page.
Come to the issue.
Pardon, I will conclude it before the lunch, madam. No problem. Kindly see the page 16 then. Page 16, the threats part to the council and to the petitioners. And the fact is this,
Mr.
that
Gupta,
the court has made it very clear, it is a court matter.
Mr. Gupta, you may now come to page, Mr. Gupta, you come to page 20 of your, rest is all we have seen is.
Kindly page 20.
Ah.
Page 20.
Now, what
Now,
you
my
want to say?
preliminary objection is to the very reference order.
That objection has already been rejected, reference has been made, now proceed further.
Well, that has not been rejected on that ground.
Yes.
I am relying on the judgment of Justice Surikant in this matter, in Aligarh University case. But kindly hear me. But on the point of the validity of the reference order, reference is to be made to settle an unsettled law. Reference is never made to unsettle a settled law. In this particular case, the reference has been made to unsettle a settled law, which was already going on for the last 65 years. And Solicitor General has agreed. Devasam Board has agreed. The state of Kerala has agreed. They have agreed to the Devaru case. The only thing where the Solicitor General has differed is only the superstitious beliefs. That is the only point which he says either it is a part of the religion, as per the scheduled mud case, you can't interfere. Within the definition of the rites and ceremonies. Rites and ceremony does not include superstitious belief. I will come to that particular point later on. But first, My serious objection is to the reference which has been made by the 3 honorable judges to the 9 judges bench directly, against all the canons of law which has been laid down by this honorable court. 3 judges. Their review petition was listed before 5 judges. And in the 5 judges bench, only 3 judges. That is Chief Justice Gogoi, who was a new one, who was not a part of the earlier bench also. And Justice Indu Malhotra and Ajay Khanilkar. Ajay Khanilkar and Indu Malhotra were there in the earlier Constitution bench judgment. So this was a reference order passed by the 3 honorable judges. And the other 2 judges, R.F. Nariman and Chanchur, they have rejected the review petition. They have said that this review petition has been filed under the pressure of the public, under the pressure of the worshippers. That's what he has admitted in his own dissenting opinion. That they have to comply with this judgment under any circumstances. This judgment under Article 141, you have to comply with it. And you are not complying and filing the review petition here. So this was so kindly see, my lord, the preliminary objections to this particular reference order.
The reference is not maintainable. We understood that.
Pardon.
Your objection is that reference is not maintainable.
Not maintainable, but there are decided
Understood.
cases I would like to
You
argue.
can come to page 33. You are relying on my judgment in earlier Muslim University.
Please,
We
kindly
appreciate that.
hear me, but I have cited certain judgments also, my lord. We are addressing a 9 judges bench, my lord. We have to bring to their notice what are the judgments which have already been passed, including your lordship.
Yes,
Judge.
yes. That's why we are pointing out page.
Therefore, kindly hear me on the point of the validity also. Because otherwise, just repeating the arguments on interplay between 25 and 26 is not going to help your lordship in this matter. Because so many arguments have taken place. These are those so many arguments which are already before your lordships, my lord. Your lordship can form the opinion. I will come in the last. But so far as the other points which have not been addressed by any side, that I would like to address. So there's something new should come before your lordship. Kindly see the 3 judges bench judgment. Para 13, page 20. For a moment.
Mr. Gupta, for your facility only, I am pointing out page 33. You are summing up by citing my judgment in Aligarh Muslim University matter. You can,
Aligarh University matter, of course, my lord. This
you
is
can,
your
you
lordship
can
was the
read
member
that
of
and
the bench.
conclude that reference is not maintainable.
Correct. So, but before that, my lord, just I will give a brief description. There is a Bharat Petroleum case, and this is a Pradeep Chandra Parija case. These are the 2 judgments where they have said that the 2 judges bench cannot refer the matter directly to the 5 judges bench. You have to first refer it to the 3 judges bench. And here the 3 honorable judges are referring the matter to the 9. In actual fact, the speaking order does not refer this matter to the 9 judges bench. The speaking order says that the matter is referred to the 7 judges. And that was the understanding was given to Arif Nariman also. Kindly see the minority judgment. Kindly see the judgment of Chief Justice Gogoi on this particular issue. Kindly see just. Yes, one minute. No, just 21. Yeah, 21. Kindly see page 21. Page 21, where the matter was referred to the 7 judges.
Yes.
Page 21.
Yes.
I may just read paragraph 4. And there was no error pointed out in the Sabrimala case judgment.
There's no dispute.
No error, no lacuna,
27.
not is it is also not per inferium also. Kindly see.
So we agree with that.
Now, can you
The
see-
question is the reference made to
Kindly
5
see
judges bench
how
or
the
the
3 honorable judges.
3 judges bench, as you are saying.
That's correct. Kindly see
The
page
bench is
4.
the bench,
Kindly see paragraph 4.
whether 5 or
Page
3.
21. Kindly bear with me. Kindly.
Majority, minority opinion will merge with majority, that's all.
I will be grateful if lordship and have a glance at page 21. Paragraph 4. Can I read it? It is time that this court should evolve a judicial policy. Well, the reference could be made on the basis of the judicial policy, evolving a judicial policy. My first objection to this one. Befitting to its plenary powers to do substantial and complete justice and for an authoritative enunciation of the constitutional principles by a larger bench of not less than 7 judges. This was the reference. This is what the Chief Justice Gogoi has done it. 3 judges bench, mention about the 7 judges bench. Then kindly see the next paragraph, what he says, and what is the basis of the reference for Ramana. Kindly see. In this context, the decision of the 7 judges bench of this court in Commissioner of Hindu Religious Endowments Madras versus Shirur Math case, holding that what are essential religious practices of a particular religious denomination should be left to be determined by the denomination itself, and the subsequent view of the 5 judges bench in Durga Committee Ajmer versus Sayyid Hussain Ali, carving out a role for the court in this regard to exclude what the courts determined to be secular practices or superstitious beliefs seem to be in apparent conflict requiring consideration by a larger bench. It is not reference to any error which has been pointed out in the Sabarimala case. The subject review petition, kindly see next paragraph. The subject review petition as well as the writ petitions may accordingly remain pending until determination of the questions indicated above by a larger bench as may be constituted by the Honorable Chief Justice of India. Now, you are making a reference for what? You don't want to review? You say it is a reference. Where we will elicit the opinion of
Mr. Gupta, objection against the reference have already been turned down by the 9 judge bench by the order of 10th February 2020.
well, I will come to that.
You are not filing a review
The
petition.
question-
You are not hearing a review petition against that order
I
of
cannot
10th
file.
February.
Well, I cannot file any review.
Please
The
don't,
question is this,
Please,
7
our
judges
time-
bench.
our time is of course not of any value, but your time is very valuable.
No.
Please consider that part.
Your Lordship
in
may
mind.
think my arguments may be totally irrelevant, but even then I will request your Lordships to
No,
hear some irrelevant arguments also.
Why should we hear irrelevant arguments? Please come to relevant arguments.
Sometimes, my Lord, in one perspective, my Lord, at one point of a time, the argument has been found to be irrelevant, and in the future, my Lord, it has been found to be relevant. And most of the minority opinions have later on been confirmed. See the opinion of the Chief Justice VP Sinha. It is minority opinion, but it is still holding. Now the matter has again been referred to Constitution.
But saying something this side, saying that.
Kindly hear me.
Say it for you, it can be reviewed. You say for other things, it can't be reviewed.
Kindly. Now see kindly the minority judgment of the RF. Well, at page 22 I have quoted. Kindly see what he has said and what he had been given the impression while he was sitting in the Constitution bench. Paragraph 1, the bold portion of it. He has then outlined 7 issues, RF Nariman says, which may be referred to a larger 7 judges bench. Also, the apparent conflict between a 7 judge bench in the Shirur Math case and Devadu case, the Darga case, Darga committee case. So kindly see, my lord, that even the minority judgment, Justice RF Nariman, who has dismissed the review petitions, he was also under this impression this matter has been referred to the 7 judges, from where 9 judges have come. I do not know. I have not seen any.
No,
All right, all right.
Noor Math has to be reconsidered. That is 7 judge bench. Naturally, 9 judges have to sit.
No, man, but I should be given an opportunity on that particular point. I should be given an opportunity. Once in the judgment, very categorically stated, if the minority judgment, RF Nariman, could follow it only a 7 judges bench, and then thereafter, the matter has 9 judges bench has been constituted.
Reason is here only.
Mr. Gupta,
Because
that
Shirur Math is
issue
7:30.
no longer is res integra. That issue is no longer res integra. Come to your written submission, page 26.
Well, I will come. Well, I will-
Just come to page 26.
I'm coming. I'm coming to that point also. Because these are the some of the issues.
Just come to page 26.
No, my lord, Justice Suryakant has asked to just explain to the latest judgment on Aligarh Muslim University.
We
on
are,
this
that's
point.
why we are requesting you,
I'm-
please come to
I'm-
page 33.
I'm coming.
Whatever estoppel you want to apply against me, why don't you do that out the,
No, my lord, now
outright
you can come.
Mr. Gupta, the problem, Mr. Gupta, problem is you are standing there and you are saying, coming, I am coming, but you are not coming.
Now I have come. Now I have come.
Come to page 30.
Page 33.
How
Kindly
many
see.
want us
The
to
latest
do that?
case on reference.
Otherwise, we will only come.
I have come now. Then kindly hear me on this point. Page 33, Para 26. The latest judgment on reference is the minority view of the Justice Dibankar Datta and Justice Surkan and Justice S.K. Sharma also, where a fractured verdict is given upon jumping reference to larger bench. In Aligarh Muslim University versus Naresh Agrawal, dated such and such, a 3-judge bench presided over by the then Chief Justice of India, while order dated 12/2/2019, made this reference to a bench of 7 judges. Here, the Supreme Court was not just confronted with the issue of the minority status of Aligarh Muslim University, but was also grappling with the jurisdictional issue relating to the validity of the reference made by the 2 honorable judges of the Supreme Court by way of order dated such and such in Anjuman versus Rahmania. Then I have quoted the portion of judgment. This is in this regard, para 92. In this regard, it is imperative to refer to the findings of the Constitution Bench in Central Board of Daud Bohra Community and another versus State of Maharashtra and another, which while adjudicating the correctness of previous decisions on the Bombay Prevention of Excommunication Act, also laid down pertinent principles on the procedure for making references. The decision in Daud Bohra essentially clarified the framework concerning how a reference should be made, particularly when a bench of lesser strength doubts the correctness of a decision of a larger or co-equal bench. It held that,
Now you
kindly see the paragraph which have been
1,
quoted.
2, 3, 4 on the next page, that will answer everything. Next page.
Well, this paragraph 12, if I
Ah,
can read, Your Lordship, kindly see. Well, this is from a Daud Bohra case. Paragraph 12, at the bottom of the page 33. Having carefully considered the submissions made by the learned senior counsel for the parties and having examined the law laid down by the constitution benches, in the above said decisions, we would like to sum up the legal positions in the following terms.
Here.
Number 1, the law laid down by this court in a decision delivered by a bench of larger strength is binding on any subsequent bench of lesser or co-equal strength. 2, a bench of lesser quorum cannot doubt the correctness of the view of the law taken by a bench of larger quorum. In case of doubt, all that the bench of lesser quorum can do is to invite the attention of the Chief Justice
Now please bear in mind every word.
and request for the matter being placed for hearing before a bench of larger quorum than the bench whose decision has come up for consideration. Chief Justice means Chief Justice at the administrative side, not at the judicial side. This was not placed. Kindly see, it will be open only for a bench of co-equal strength to express an opinion doubting the correctness of the view taken by the earlier bench of co-equal strength, whereupon the matter may be placed for hearing before a bench consisting of a quorum larger than the one which pronounced the decision, laying down the law, the correctness of which is doubted. Paragraph 3. The above rules are subject to 2 exceptions. The above said rules do not bind the discretion of the Chief Justice, in whom rests the power of framing the roster and who can direct any particular matter to be placed for hearing before any particular bench of any strength. I'm coming, my lord. This is on the administrative side,
Yes, yes.
not at the judicial side. In spite of the rules laid down herein above, if the matter has already come up for hearing before a bench of larger quorum, and that bench itself feels that the view of the law taken by a bench of lesser quorum, which view is in doubt, needs correction and reconsideration, then by way of exception and for reasons given by it, it may proceed to hear the case and examine. Next page. Correctness of the previous decision in question dispensing with the need of a specific reference or the order of Chief Justice constituting the bench, and such listing, such was the situation in Raghbir Singh case also. 93. The principles enunciated in Daudi Bohra case enforce the provisions of the Supreme Court rules referred to earlier and also reiterate the well-established principles based upon doctrines of predictability, consistency, finality, and the principles of stare decision. The 2-judge bench in Anjuman ought to have been understood and applied the law consistent with these principles. The 2-judge bench in Anjuman Supra being lesser strength than the 5-judge bench in Aziz Basha case lacked the authority to explicitly question the correctness of Aziz Bhasa and refer the matter to the 7 judges. The next 94, in Anjuman, the bench not only referred.
So have you understood para 93?
Now,
Have you understood para 93
No, what
in the
should-
context of the factual history?
I will then read the minority judgment of Justice Shurkant in this matter,
We
because
are
that
not-
will clear.
Let's not read all those things. You now come to para 97 and 98, that's all.
97. 97, Your Lordship, I am grateful, my Lord. In this light, we respectfully disagree with the opinion of the Honorable Chief Justice that the reference in Anjuman passes muster. Such a reading risks opening the floodgates to further complexity and disruption, where smaller benches could disregard established principles and overturn decisions of larger benches. This would erode the concept of well-settled principles and destabilize the legal framework. As such, judgment would strive to chart new directions, undermining legal certainty and continuity. Ironically, the reference in Anjuman.
Ironically, the reference in Anjuman Supra strikes through the very core of Daud Bora and the law laid down therein. Now read para 98.
I'm obliged, my Lord. Then, my Lord, skipping over, then I'm just reading the
Para
minority.
98 also, and then sum up this argument. Let us finish this argument.
Then, page 37, paragraph. Well, these are the issues which are to be decided first, because the reference is under question is very doubtful. What you cannot achieve directly, you cannot achieve indirectly. You want the Sabrimala to be reviewed, but you don't want to say, because you could not find out a single error in that judgment. And what you are doing, you are taking around about there are so many cases, and therefore a judicial policy is to be evolved, and therefore the matter is referred to the 7 judges. Then all of a sudden the matter comes before the 9 judges. And I was never given any opportunity to argue on the validity of the reference order.
No, sir.
For the first time I'm arguing.
No, sir. Come to page 26.
26, sir.
Yes.
Already been answered.
Page 26.
Come to page 26.
26,
of your
I'm just-
additional
I'm obliged.
written submissions.
I'm obliged. I'm
You
just,
yourself quoted
page 26, my lord, paragraph.
26, begin from the last,
Para
paragraph
23.
22, starting at the end of page 25. Please read that out and then make your submission.
Yes, 10/2/2020. This
Yes,
proceeding,
10 to 2020.
correct. That all the reference made by 3 honorable judges was to only 7 judges.
Yes.
The then Chief Justice S.A. Bobde referred the matter to 9 judges bench. Nobody can refer it to the 9 judge bench.
Sir, please read it. Please
The
read it.
relevant paragraph 5 is quoted under.
Yes, now read that paragraph.
The bench of 9 judges was constituted by the Chief Justice of India to answer the reference. At the threshold, upon the objections raised by the party taking exceptions to the reference, that was a different objection. I will come to that particular point. And an issue as to whether this court can refer questions of law to larger bench in review petition was in review petition. That is very important. That was the issue. Their request to hear the issue regarding the maintainability of the reference as preliminary object questions was acceded to. And we have heard the learned counsels for both the sides under maintainability of the reference. My lord, what was objected to? Just I will tell you. I was not heard in that matter also. I was also not heard at the time of the framing of the issues also. I was completely excluded. Read petitioner counsel was completely excluded when the issues were
Read
framed.
that further.
Sir, just a minute.
Kind-
Why this one? When I raised the objection, my lord, before the 9 judges bench, all of a sudden from the other side, they came out with a plea that this reference could not have been made in the review petition, because there is a lot of dichotomy. This reference order has not been registered as a reference case as per the Supreme Court rules.
Yes, that is
It
exactly.
is a review.
Sir,
Kindly say.
if you read the order, next
Next
paragraph,
Next paragraph.
11/5/2020 order, you quoted a paragraph there, if you. would-
Undoubtedly, I'm reading, but I'm telling you what was the context of the challenge.
With respect,
Ah.
if you go through that order, what you are canvassing before us today
I'm
was exactly.
I'm only on
raised.
different platform.
You were-
in the
was
reference order.
Exactly raised.
I'm
by the
coming. I'm
Supreme
coming.
Court.
I understood your last
Do
question.
not permit a reference on a review petition. Then the power of the Chief Justice to make the reference was traced to an Article 32 petition. And it was said that in Article 32 petition, the power of the Chief Justice is not governed by the Supreme Court rules. And this decision in 11/5/2020 was passed by the
Chief-
earlier 9-judge bench
And-
and remains binding on this 9-judge bench.
May I clarify
And
on
you
this issue?
please
Malad?
now come to page 40 and I think then you can
Page
put
20.
your argument.
40.
Page 40, last paragraph where you are quoting my opinion. If you read next two paragraphs, that
Page
your argument
40.
is complete.
That is a judgment. Just kindly see page 39 bottom.
39 we have seen. After that 40 you can see.
Page 40, this
40.
it is in continuation. Last two lines of the page
Yes,
39.
yes, please.
It is. Justice Dibankar Datta. My lord, Justice Dibankar Datta was sitting along with Justice Surikant and Justice S.K. Sharma, my lord, has attempted to clarify and reconcile the conclusion drawn by the Supreme Court in Central Board of Vora and a case. Insofar as smaller bench cannot dictate the numerical strength of larger bench, as that discretion lies solely with the Chief Justice of India. That's what my contention is, in his capacity as the master of roster, but on the administrative side, not in the judicial side. When a smaller bench doubts the correctness of a decision of a larger bench, it has only two options available. First, it may place the matter before the Chief Justice for consideration without prescribing or directing the composition of the proposed larger bench. Second, it may refer the matter to a bench immediately higher in strength for reconsideration of the earlier view. Only a bench of co-equal strength can doubt the correctness of an earlier decision passed by a bench of equal strength, upon which the matter may be placed for hearing before a bench consisting of quorum larger than one that delivered the original judgment. Now, kindly may I proceed further, or I may just skip over and then come to the bottom. Justice Surikant judgment in paragraph 94 really encapsulates the precise problem with the reference order in Anjuman Rahmania case.
Now please read carefully 263.
Kindly see, my lord, this judgment, minority judgment. Sometimes minority judgment, my lord, are becomes in the future much more important than the majority judgment.
Yes, yes. Read para
Therefore, the
Therefore,
judgments are overruled, my lord. In one way or that way, my lord.
Mr.
Kindly see.
Gupta, listen to us. I think we have no difficulty in listening to you. Here,
Here, this
you are
side.
looking everywhere except me. Is it nice?
I'm sorry, my lord.
All right.
My lord, I have a cataract operation, my lord. I'm sorry, my lord.
We
I have
understand.
two problems, my lord, physically. One is of the eye and of the ear also.
But we don't have difficulty in hearing your argument, no problem. See,
Thanks to God, there is no problem with the tongue. So,
see, we'll tell you what, see. We understand.
just
Why
bear
don't
with.
you listen to us now? You don't mind, our problem is you're not listening to us, that's a problem.
You have to hear,
Yes.
not just listen, hear, my learned brother.
Kindly,
See,
well, I'm sorry, my lord. You're like-
There is a beautiful saying in our, in Ramayana in our place. When Rama threw the arrow through Tadaga in Tadagavada, he explains, it gets him so fast and then pierced it and went away so fast. Like a sane voice of a learned man to a man who does not want to listen. So it'll come so fast, it'll go so fast that's the explanation is given. It is just like that. If you want us to listen, then you have to just listen to us also. We understand your argument. You are laying upon the Chief Justice's argument. We also accept it. As my brother has put it, he asked you to read para 22 and 23. Now this is 23, para 22, it actually says 7 judge, reference to 7 judge, not challenged. Then the Honorable Chief Justice and the Administrative said, that's what my Chief is saying. He referred to 9 judges bench.
9 judges bench.
That is an administrative order, he referred to it. It's not a judicial order.
Well, how can,
And what now you were saying that is in line with the observation made in the other judgment.
my lord,
It's a discussion
7
with
judges
Chief
bench,
Justice.
7
He
judges bench
accepted
was
the
never
nine.
constituted.
Mr. Gupta, the problem in Anjuman
Ah.
with regard to the legality or validity or propriety of that reference,
No, that's my lord.
I have just tried to sum up in 3-4
I'm
lines.
reading, my lord. I'm going to start.
Page 41, para 263,
That-
that respond to
Your
you.
lordship, I'm obliged, my lord. Kindly see. Can I start from the top?
Yeah, in Anjuman, yes.
Page 41.
Yes, please.
263. In Anjuman,
Yes.
the bench not only referred the matter, but also specified the numerical strength of the bench to which it should be referred.
Now it is a two-judge bench.
Two-judge bench.
Anjuman is two-judge bench.
Correct.
The bench not only referred the matter but also specified the numerical strength of the bench
Ah.
to which it should be referred to.
Your
A
Lordship,
further direction that the matter be placed before the Chief Justice for the limited purpose of notifying the composition of the seventh judge bench.
correct.
Yes.
So that's what I am saying. 3 judges headed by Chief Justice Gogai, 3 judges only, 2 have dismissed. They have referred directly to 7 judges. As what is written. Then in the chamber, it was referred to 9 judges.
Yes.
At the administrative
Now
side
just-
or whatever side,
Just
there
read
is
the
no
next line.
proceedings where the matter has been referred to the 9 judge bench. At least I could not locate any proceedings. Either the matter was referred to the 9 judge bench. It was only to 7 judge bench, and that what was the impression of the Justice R.F. Nariman also. That the matter is going to be referred to the 7 judge bench, not to the 9 judge bench. And there is no need at all.
Now just read the next line.
Kindly see. Paragraph 264, my lord, if your lordship can.
263, you can read the left out line
Ah.
because thereafter you can proceed to the next point.
At our command, we do not appreciate as to how a 2-judge bench could dictate its viewpoint to the Chief Justice of India. This, to our mind, effectively impaired the Chief Justice authority as a master of the roster.
Yeah.
Allowing such a practice would enable benches of lesser strength, such as it to the judge bench, to undermine the decisions of the larger benches, potentially even an 11-judge bench.
So this reasoning does not apply when the Chief Justice himself is presiding the bench.
My lord. The
Now
power
please
should be the
proceed.
Chief Justice of India. But at a judicial side, the Chief Justice Gogoi has taken a view, 3 judges bench, referring to the 7 judges, without referring to the 5 judges bench.
All right,
So-
now next point.
That's it. So kindly see page 264 also, just I can just read, my lord. We reiterate that such actions completely undermine the principles of stare decisis, as well established doctrine that mandates the consistent application of legal principles once pronounced by authoritative courts. This principle is rooted in the idea that once a court has determined a rule applicable to a specific set of circumstances, it should be followed in all future cases involving substantial similar facts. Then, my lord, kindly skip over, then come to the, that's one.
You can now come to your part 3, page 50,
Page
page 50,
50.
part 3.
Then, my lord, the presidential reference also, my lord, just for a moment. Because presidential references 2 or 3 times, my lord, has been referred back to the president. Under Article 143, in Ayodhya case, the reference was there, I was there at that moment of a time. And in Ayodhya case, reference was challenged by R.K. Garg. And this court, after dealing with the entire propositions, then he came to this conclusion that these questions cannot be answered. This is another aspect of the reference one. Apart from validity, at the preliminary stage, whether such and such judges, this bench could refer it to the larger bench, is keeping the middle bench. There is another issue here is this, whether the issues which are referred to your lordship, and I've already stated, when the issues were framed, the counsel for the writ petitioner was not included. There is a speaking order of the Chief Justice Bobde. He has selected some few senior lawyers and said that they will decide what will be the issue. We should be added to it. And that has been given the stamp of approval by the Chief Justice Bobde. That these are the issues, 7 issues. So those issues, I was not there. Now those issues, if had been there, I would have also incorporated the issue relating to the validity of the reference order. So I could not incorporate that particular issue.
Now you can come to your preliminary submissions.
Now-
Right.
Sorry, man. Now, so far as the presidential reference is concerned, my lord, this is kindly see, there are page 43, kindly see.
Presidential reference is over, Mr. Gupta. Now you can come to page 50. 50.
Well, one thing I want to make it clear, in the presidential reference, there is a specific provision in the Supreme Court rules. The problem, my lord, because we are the advocate of the courts, so we know how to deal with the history and how to deal with the Supreme Court rules. The senior advocates may or may not enlighten on that views. Whatever your lordship, the Chief Justice of India has got the power to constitute a bench Here the doubt has been created. Can he constitute the bench of any number of the judges? Can he constitute the bench of the 11 judges or 13 judges for overruling a bench of the 3 judges bench? There has to be certain guidelines.
That has
And
not
there-
happened.
Huh?
That has not happened, so you don't have
Ah,
to go
that's,
into it.
that's correct. Therefore, since the Chief Justice being here, it requires a little bit amendment also. Because this case has not been registered as a reference case. Presidential references cases are always registered as a reference case number 1, 2, 3, 4, like this. And so far as these references cases, because your lordship is saying, I'm not saying, because reference case in a review petition, and then your lordship says it is a reference case only. Reference case has not been registered under the Supreme Court rules. So there has to be a little amendment. So there has to be a little amendment, very little amendment in a provision that reference case must be separately registered where there will be no parties. Now, my problem here is what? The same review petition cost title is here. And your lordship is hearing the cost title, hearing the reference within the parameter of that cost title. Now, suppose if in case your lordship decides something, it will be taken as decided within, in the review petition. And then later on, in the same brief, your lordship is saying, the court says that after this matter, the review petitions would be listed, the same review petition would be listed then.
Mr. Gupta, we understood your point.
Correct.
It's a good suggestion for our consumption or administrative side. We will consider that part.
Correct.
75 years, whatever practice
my
has
lord-
been followed, has been followed.
Huh.
But if you want a new practice to be introduced, maybe that you have a good suggestion, we will consider that.
Now,
Now
so
you
far as,
can-
my lord, only the, just 1 minute, 2 minutes I will have it. So far as the reference is concerned, presidential reference, which is very important. Is
Why are you unnecessarily wasting time on presidential reference?
only 1 minute I will take. Why I am saying is this. The merit of the reference will also be examined by this honorable court. At one point of a time, just 1 minute,
Mr. Gupta,
ladyship has once remarked, I've heard of, I do not know, I may be incorrect. It appears to be a case of panic in vacuum. These were the remarks of my ladyship.
Not use that expression.
I don't know. Well, I may be wrong. Well, I'm sorry for that. I'm sorry for that. So, at what point of a time there was a need to make such a reference? Your lordship has to see all the issues and then say that, well, I'm not going to answer any issue,
we have understood your argument.
collectively or individually. We will not give any answer to this issue, this issue, this issue, this issue. I will, to collectively or individually, as in the presidential reference also, the court has said, well, I'm not going to answer these issues, which have been sent by the President of India under Article 143 of the Constitution of India. So your lordship has also to examine whether every issue is to be addressed by every judge of this court, or the judge may say, well, this is well settled, I'm not going to disturb anything, and we are not going to answer this issue. Kindly see next.
Now you come to page 50. You have
Ah,
preliminary objection.
Now, preliminary submissions, my lord. I'm grateful to your lordship. Page 50, para 31. Now, there are certain preliminary submissions which I have made. Before coming to the merit, 2 or 3 things are very clear. This is a reference case. This is not a review petition. Or the cost title is of the review petition. So far as Sabrimala is a religious denomination or not, that has been conclusively decided by 4-1, and it cannot be obeyed. Why? Because there is no such issue referred to your lordships. Even what are the essential ingredients of constituting the religious denomination? That will also not be discussed by your lordship. Some have tried to address on those issues, but this is not the issue here. Conclusively, it is. So it cannot be disturbed. These findings are. Now, whatever the Sabrimala has to take the help is of the non-religious denomination.
We understand. One next one.
Kindly see. Next. So far as the rule 3B is concerned, 2B, 3. Kindly see. 3B. Of the Kerala Hindu Places of Public Worship, Authorization of Entry Rules, 1965, page 51. That has been declared to be ultra vires by the 5-1. This has also not been referred to any of the issues which it relates to. So it is also conclusive and final.
Yes.
So Sabrimala case cannot be touched, whatever may be the reference order, whatever may be the judgment. Sabarimala case cannot be referred to, it cannot be reopened. It is final and conclusive, and your lordship has to implement that particular order, despite all the public protests or the protests.
We already said we agree with you on this topic. Yes,
And
yes.
I'm of less, my lord. Kindly see next, my last on merit. Well, I will take it to the history, my lord, of India. In context of the Indian history, then only this could be examined. Religion is such a thing, my lord, I will come to later on, my lord, that it cannot be defined under any circumstances. Submissions on merit, superstitious beliefs, oblique accretions. That the Solicitor General on behalf of the Union Affidavit, that is very important, my lord, where we are differing to from the Solicitor General, agreed that in case of conflict between Articles 25 and 26, they should be harmonized to the extent that while giving right to religious denomination under Article 26, right of individuals under Article 25(1), and that of a state to make law under 25(2) may not be reduced to husk. But the husk is very important in the judgment of the Devaru case. You can do harmonize. What is the problem? No problem. But don't reduce the other side. To reduce to such an extent that it becomes husk. There remains nothing of that man. So therefore, Devaru case has harmonized in such a manner. And now the question here is this. He has also agreed to the extent that Devaru case is correct and there is no error. Gopal Subramanian has also agreed to this proposition, if I am not wrong. Extent. Devaru case is correct and there is no error, wherein Shri Venkatramana Devaru versus such and such, at page Justice Venkatramana, if the denominational rights are such that to give effect to them would substantially reduce the right conferred by Article 25(2)(b, then of course, on our conclusion that Article 25(2)(b prevails as against Article 26(b), the denominational rights must vanish. But where that is not possible, position, after giving effect to the rights of the denomination, what is left to the public of the right of worship is something substantial and not merely the husk of it. That is very important, husk, expression husk. There is no reason why we should not so construe 25(2)(b as to give effect to Article 226(b) and recognize the rights of the denomination in respect of matters which are strictly denomination, leaving the rights of the public in other respects unaffected. The state of Kerala has already stated in their affidavit, women of all ages must be allowed. This is the state. Well, I will just explain the state of Kerala. And when I filed the writ petition, left government was there. They filed the affidavit. They said that the women of no ages should be debarred or should be allowed. Thereafter, the government had changed. When the matter came after notice, they changed the state. And they filed another affidavit. Then Chief Justice Deepak Mishra was quite annoyed. They said that if you are filing the affidavit in such a reckless manner, you are changing the stand because of the change of the government, we are not going to allow. Make your stand clearly that what is your stand, whether the first affidavit or the second affidavit. Then the state of Kerala Council has said that, well, I am relying the first affidavit, but it was the first affidavit. And very categorically, I have stated that the women of no ages should be debarred. They all should be allowed. So this is what the state of Kerala. Therefore, I am saying that Union of India, state of Kerala, there was some, all are in our favor. Except 20 or 30% in the last year, they deviate. Kindly see. Then the state of Kerala, the next page, 54. The Solicitor General, however, differs over the ambit of Article 26(b) and says superstitious beliefs. Here is their diversion, and which I highly oppose the submission of the Solicitor General on this issue. Just wherein then Justice B.K. Mukherjee at page 208 categorically observed under Article 26(b), therefore, a religious denomination or organization enjoys complete autonomy in the matter of deciding as to what rites and ceremonies are essential according to the tenets of religion they hold, and no outside authority has any jurisdiction to interfere with their decision in such matters. The petitioner submits that this interpretation of Solicitor General would bind the judiciary and would strengthen the hands of those who are practicing witchcraft and befooling and cheating the innocent people from the last several centuries, which had a firm rule in India for more than 1000 years. It is submitted that subsequently 5 judges bench in Dargah committee case reporting such and such realized this lacuna, and therefore the then Justice Gajendra Katkar clarified that one should not get confused with many accretions added in due course of time to the core set of rites or ceremonies practiced by religious denomination. He observed at page 411 and 412 that in order that the practices in question should be treated as part of religion, they must be regarded by the said religion as if essential and integral part. Otherwise, even purely secular practices, which are not an essential or integral part of the religion, are apt to be clothed with the religious form and may make a claim for being treated as religious practices within the meaning of Article 26. Similarly, even practices, though religious, may have sprung from nearly superstitious beliefs and may, in that sense, the extraneous and unessential accretion. Well, this is very important. What Justice Gajendra Katkar was of this opinion. In religion, since it is coming from a very long ages, a belief was a very good belief. And then later on, subsequently percolated into a dogma, a religious. So he says accretions in due course of time, which converts into superstitious belief. So that's what Justice Gajendra Katkar has departed. And it's written like this. And where my learned Solicitor General has also deferred and says that it is within the ambit of the page 55. Since most of the religious denominations like Sabrimala, Ajmer Dargah are ancient institutions, many rites and beliefs may get added in due course. So the core religious practices could be permissible under Article 26, but not all historical accretions, including many ill practices like superstitions, which may in due course of time may get added to the basic theme of that religious denomination. The Solicitor General failed to appreciate the danger of religious horrors practiced in many parts of this country, not in the country, abroad also, my lord, which do not fall within the ambit of rites and ceremonies. Now kindly see the Khajuraho temples, my lord, and some Odisha temples, my lord, which are being erected on the advice of the Agmas. Kindly see, para 34. It is submitted that if superstitions were permitted in the name of religion, and even judicial review is not permitted, 32, 142, 226 has no value. Then whatever has been achieved since abolition of sati in 1829 shall be undone at the very apex level. It is submitted that voluptuous images in the form of Mithun over the outer walls of Khajuraho temples between 885 AD to 1050 were for the purpose of pleasing the bhutas oblique spirits, which is perfectly as per the architectural design proposed by Agmas, as per Agni Puran and other Hindu religious scriptures like Brihat Samhita, Matsya Purana. Next please. In construction of Vishnu temple, Torana of the same should be decorated with Mithuna sculptures along with other essential items like Vidyadhara, Gandharva, loin, tiger, etc. Similarly, the Agni Purana have also beautifully concluded that the last 4 shakas, division of temple, should be decorated with erotic imagery. The Brihat Samhita, a treatise of 6th century, have also referred that the door of any Saivite temple should be adorned with the figures of birds, trees, pots, and with male and female figures, as well as those leaves, creepers, and other fiend attending on Shiva. Regarding Khajuraho temples, Kyan Brata Chakravarti, my lord, he is a very...
So what is your argument here?
My argument here is this, that suppose if they go to the extreme side, that the judicial review should not be.
You forgot about them, you concentrate on your.
I'm coming to that particular point. Now kindly see, my lord. For example, if your lordship hold it, there are 2 aspects, judicial review and thereafter whether it should be permitted at all. Suppose if it is being found to be a part of the religion, it is a part of the Article 26B, and court cannot look into it. Now they say, so far as the Khajuraho temples, the images which are there, which the Mahatma Gandhi has said that it should be raised, but it's still persisting. Suppose if I erect a Khajuraho temples type of temple in my colony, and the inhabitants are objecting to it, then This court cannot look into it because it's a part of the religion. So where we will stand? Not only Khajuraho temples, in several Orissa temples also.
Mr. Gupta, we don't want that religious debate here.
Well,
If
unless
you do
the
not
worship
know
not
anything
appreciate the
about a
ambit-
temple,
ambit
if
of
you
the
do not know
misuse.
anything a temple, please don't argue, raise an argument only for the sake of lifetime.
Other examples,
Telecast.
kindly see the other examples.
You have no knowledge of these temples we are referring to. Your knowledge is extremely poor if you want us to quote.
No, but so far as these
Now,
other
please proceed
temples,
further.
the worshiping is
Don't
going
waste
on.
our time also now.
Now, next kindly see the.
You have absolutely no knowledge of any these things.
Now, kindly,
You are
see,
referring to.
kindly see page 57, the Gita, what the Gita says, my lord. Can I quote the Gita, my lord? Kindly see page 57, what the Gita says. Paragraph 36, my lord, bottom page 57. I am just quoting 2 lines of the Gita. Holy Gita mentions about worshipping bhutas by depraved kinds of people. This has also been mentioned in chapter 17, shlok 4 of Gita, where few depraved sections of society worship them. Next page, 58. Kindly see, my lord, the middle portion I have given the English translation, my lord. Your Lordship got the middle portion at page 58, what the Gita says. Those in the mode of goodness worship the celestial gods. Those in the mode of passion worship the yakshas and rakshas. Those in the mode of ignorance worship ghosts and spirits. So this division has been made, and in Gita it has been mentioned. Then your Lordship has to see that religion, if you leave the religion,
Your entire translation is wrong. You have no knowledge of these Sanskrit words, and you are wrongly translating and giving a complete
I do not-
feedback and misdirecting us.
I admit I do not know this.
Therefore, why you are relying upon when you do not know the subject?
This is only, my lord, I can give the source of the.
Confined to your legal, we have already told you that we are only within the framework of 25, 26. Who
26.
is asking you to explain, yes, what is the Yaksha and what is Rakshasa?
My submission before Lordship is this.
The translation of Rakshasa.
26.
Most-
I may, your Lordship may be correct. Because whatever I could catch hold of, I have given and I produced it. And I have also given the meaning of each and every word which has been used in this shlok. That is also the person.
What
He may
is
be
your,
right,
what
he
is
may be
your
wrong.
argument? What is your argument?
No,
Apart
I'm
from
coming.
drink.
Religion.
Mr. Gupta, we will read this portion. I think the most important arguments is capsulated from page 74 onwards.
Well, I'm coming to 74. Mala, I'm at
Please
page.
see
I'm sorry,
from
Mala, I'm
page
obliged.
74 onwards,
Mala,
they
I will
are
come.
more focused
I
on
will
the
come.
questions. Other
Then
than
kindly see-
history about religion, we will read it.
Now kindly see, my lord, just thereafter, my lord, that page 59, paragraph 38.
Go to page 75.
I'm coming, my lord. But before that, at page 60, the National Crime Records Bureau, an office attached to the Indian Ministry of Home Affairs, started collecting data on human sacrifices. At page 60, paragraph 39, human sacrifices. This is a Government of India record. Then I may skip over it. When these children are sacrificed, they are usually mutilated. Page 61, quoted portion. Their ears and nose are sliced off to unleash a stream of blood, which is collected in vessels and offered to goddess. In Krishna case, a hole was drilled into his head to facilitate this. Several tantrics are known to drink the blood during the ritual, which is usually performed on new moon and full moon nights. Next, kindly see. Then I will skip over this one. Now come to the page 60.
And come to page
Page
75,
75.
that will help you, sir.
Malab, very important,
75.
very important is the, is just
That part you please leave
Madam,
us to. leave-
one very important is the Sati
Please
Pratha.
leave us to read it.
Malab, I will just read.
Save your time, sir. We are worried about your time.
So many other senior councils are there.
I mean,
We
I
will
correct,
read this
Malab.
portion.
Kindly see,
From 75.
I am only going to read what the Privy Council has held in the Sati Pratha.
That will
case.
read, sir.
And whatever the other side mindset is,
The
the same mindset was reflected before the Privy Council also.
is not disputed to fall within questions of public order, which is a exclusionary clause for Article 25 as well as 26.
Ah.
It doesn't really trouble us. There's no dispute intricacy. the issues that you are addressing more relevant come from page 74, 75.
75.
Please address us on that.
My submission is only this. 26B cannot be expanded to include superstitious beliefs.
Perfect.
We
And therefore,
appreciate,
I disagree with the social
we
denomination.
appreciate that part of your contention, but that starts from page 76, para 51.
I'm coming.
Please come there. It makes a lot of sense what you probably want to say. We will appreciate that part. We
Then-
may agree, we may not agree, but you please come there.
Now I'm coming to
Mr.
page
Gupta,
75.
Mr. Gupta,
That's a wonder.
you can put it in a single line. See, you can see, actually, the learner at Solicitor General try to restrict his own power. You can say the power is rather wide to cover social welfare, social reform, and the third part of entry. What constitutes is a different thing, but 25(2)B gives a power. Though he himself is circumspect in saying we don't wish to exercise it, except but he gives an example of these are the areas we probably venture into.
Several superstitious
Actually, yeah, he wanted to just,
witchcrafts, etc.,
yes, sir.
which are prohibited by law by several states by making legislative.
Other words, his argument is such a power can be used very sparingly on a given situation, because obviously it will have a reflection on the religious practice and therefore religious belief. We are quite conscious about it. It is not for us to trigger it by assignment required.
Yes.
Unless we are satisfied the parameters, we will not do it. But for that, they are saying, we understand the argument, hope you will also be appreciating that. That is why we put a question to you, under which power you amended section 6 of the Hindu Succession Act. He said 26(2)B. Is it a superstition or something like that? It's a reform. When it comes to reform, it can be done. We understand your argument, no, it's your fault. Yes.
Exclusion of the
Entire
judiciary.
Hindu code bills guidance is a part of reform under 20.
That's it. All right,
If he agrees, there is no problem.
very well, go on.
It should be noted down. And now kindly see page 76, religion. Well, page 76, I am coming to page 73. Paragraph 51. That a combined reading of articles 25 and 26 would show that constitution makers have provided for 3 rights, namely the individual rights to religion, rights of religious denomination to manage, 3 states' right to regulate various aspects of the religious affairs. Now, next paragraph, it is subject that religion has not been defined in the Indian Constitution. So there could not be any fundamental right of any individual or group of individuals over any religion, nor they can claim any authority over the same. No one can issue any fatwa or command on behalf of any religion existing from the time immemorial. There are no legal successors surviving who could have claimed any right over the same. This right to religion is only given to religious denomination or section thereof. The expression any section thereof in Article 26 pertains to the said religious denomination and not independently. Therefore, constitution makers have guaranteed fundamental right to only religious denomination and not to any follower of general religion existing from the time immemorial. Except this, kindly see next page, that I've already clarified, it has come during the course of the argument. That the expression person which has not been defined in the constitution is defined in the General Clauses Act, clause 42. And there the body corporate is there, administration is there. So non-denominational religious groups, they enjoy the right under Article 25. There is no problem like that. They can enjoy within the definition of the person. Page 77, I have quoted that particular provision of the person as such. And listen. So they enjoy. Now page 78. Now I will just give the position of other countries, about 10 or 12 countries, what I have seen the constitutions. So I will be reflecting their positions in their constitutions. Page 78, paragraph 53. May I read, my lord? Page 78, paragraph 53. Paragraph 53. Should I start, my lord? Should I? Kind of. Page 78, paragraph 53.
Yes,
That this right is not confined to only his or her religion. Very important, my lord, I am telling. It is a new argument altogether before lordship. The expression his or her is significantly missing, like in Article 38(1) of the Constitution of Nigeria. which provided that every person shall be entitled to manifest and propagate his religion. This his or her is missing. So I can practice any religion or belief in worship. On the other hand, the constitutions of Bangladesh, Vietnam, and Uganda expressly provided to every person right to practice any religion. For example, Article 41A of Bangladesh Constitution provides that every citizen has a right to profess, practice, and propagate any religion. They have categorically mentioned in their constitution. Similarly, the Article 24(1) of the Constitution of Vietnam provided that everyone has a right to freedom of belief and religion and has a right to follow any religion or to follow no religion. All religions are equal before law. Similarly, Article 29(1)(c) of the Constitution of Uganda provides that freedom to practice any religion and manifest such practice, which shall include the right to belong to and participate in the practices of any religious body or organization in a manner consistent with this Constitution. Then see the Constitution of Ireland. It was so because our Constitution borrowed principles from Article 44 of the Constitution of Ireland, which has confined rights to only religious denomination. Pakistan Constitution too followed the same principle as laid down in Indian and Ireland constitutions. The other reason could be that, next page 79.
Very good.
All right, we understood that part.
Now kindly see.
Then you are referring
Then-
to HM Sirvai at page 80.
Is I'm a blessing. At page 80, kindly see that. Third line from the top. The religious institutions carry many religious activities, ritual ceremonies, and without entry into the same, one may not fully practice religion. H.M. Sirvai in his book, such and such, in the para 12.50, it is obvious that religion has both a personal and institutional side. No doubt, men may pray in their homes and hit the heaven with their prayers. But throughout the ages, men have worshipped in temples, churches, mosques, and the like. In practice, the personal light is inseparable from the institution, and a person would justify complain that he had been denied the freedom of religion if the right of private worship was conceded, but the right of public worship was denied. Article 25 to 28 recognize this twofold aspect of religion. Thus, right to practice religion includes right to entry in the public religious institutions. This right is not limited to citizens, but to all persons of any faith. Well, this is very important. This is my separate arguments.
Well understood.
I can, as a matter of right, can go to the masjid. Nobody can, provided we follow their rituals, whatever they have laid down. It does not restrict one's right to his or her own religion, but to freely profess, practice, and propagate any religion, thus barring a case of FGM, female genital mutilation, my lord, FGM I have given in short, which is not only unconstitutional, but also penal in nature. Other 4 cases related to entry of women where constitutional makers have not only given ample protection to the religious rights of women, but have made it at part with men using the expression equally in Article 25 of the Constitution. The next expression, freely, while my learned sister was emphasizing upon the word freedom, freely, is very significant, as there are no fetters over the right till it does not disturb public order, morality, and health. Thus, entry into religious institutions being part of this right could be exercised freely under Article 25(1). It may be submitted that the expression free is concomitant with similar rights of freedom. Next page, guaranteed under Article 19(1). But this right under Article 25(1) has been codified separately from Article 19(1)(a) to (g), while providing for certain rights under Article 19(1), like right to freedom of speech and expression, right to form association and assemble, right to freely move in any part of the India, including right to trade and profession, etc. The Constitution makers took care not to provide for right to profess, practice, propagate religion in Article 19(1), because the rights under Article 19(1) are limited to only citizens only, while right under Article 25(1) is available to every person. It may be stated that in several constitutions, this right has been clubbed with other rights. For example, in Article 29 of the Constitution of Uganda, religious rights have been clubbed with other rights by providing that protection of freedom of conscience, expression, movement, religion, assembly, and association. Similarly, in Article 2 of the Canadian Constitution, while providing for religious right under Clause A, Clause B, provided for freedom of thought, belief, opinion, and expression, including freedom of press and other media of communication, Clause C, provided for freedom of peaceful assembly, and Clause D, provided for freedom of association. Since religion has always been regarded as very intrinsic to human living, like right to life and liberty guaranteed under Article 21, and so every person has been given separate right under Article 25(1), subject to public order, morality, and health. It is subject to the expression free, appearing anywhere like in Article 19(1)(a), carry with it corresponding duty, so as not to disturb others' right to also exercise their right. There is no such concept like absolute freedom, and which may create disorders, and hence this right has been made subject to public order, which could be ordained not only by state, but also by religious institutions. Again, the expression freely does not mean that one can engage in any kind of ritual. Again, I am coming to that particular point. You can freely exercise, but not any kind of the freedom, any kind of the ritual. If the expression freely is to be read in juxtaposition with the expression equally, it would mean that every person can exercise this right, which includes right to entry, freely at par with everyone subject to public order, health, or morality. If this right is exercised at the place other than religious institutions, then the same shall be subject to public order maintained by state. But if this right is exercised freely and equally in religious institutions, then the same shall be exercised as per reasonable and non-discriminatory norms laid down by their managements. The next expression, belief, my lord, that's very important. Although this issue was not in the Sabrimala case, my lord, because what was there in the entry point? Entry is not the belief. It is the your belief cannot be this, that, well, my belief is this, I will enter, you will not enter. This could not be the belief. I don't agree with that belief. Para 56. The next
So
expression.
that means people who did not have any faith or belief in that Lord want to enter the temple.
Well,
That is your
if-
case.
Yeah, will you take the undertaking before the entry of the temple?
No,
If this is
your-
the undertaking you
your
give me
case
that you
was-
believe in this faith.
Your case was people who don't have faith and belief in that deity, allow them to enter.
No,
That was your plea before
how
the
your ladyship,
court.
how your ladyship has come to this conclusion? I do not have the
The whole
faith.
case they are saying from
No,
what you have been arguing.
I am having full faith, therefore I am entering.
A person.
I have given the
who has-
example of Balaji Mandir.
See, this is quite serious. A person who has full faith and belief in the Lord or the deity, the goddess,
Naturally,
will follow what is required for the performance of
course.
worship.
Of course,
If any such devotee is saying, I will break all
not that.
niyams and even then I will enter,
No, but
such person cannot be encouraged by this court.
I understood your,
What we are saying.
I understood your ladyship.
It's a question of belief. We are not on superstition. We are leave aside
I'm not-
superstition. We are on the serious issue.
Uh.
Anybody saying who has faith and belief in a particular deity, Lord, goddess, let us take, or even any other, religion
course,
also
Of course,
wants.
I
to-
agree.
Yes,
I agree.
such a person will not say, I will break the niyams and this court must give me the support for
But
it.
it is not in this case, Bala. In Sabrimala case, it's not the case.
What else?
Sabrimala case, the case is this, that I am entering with a firm belief to follow all rituals which are prescribed for any worshipper in the Sabrimala temple. But you say, my belief is this, I will go, you will not go.
You are not a true believer.
That's what in the Kerala division
You are
of
not
judgment is
a
there.
believer in the true
See, the Lord Ayappa does not like young ladies, from where they brought it. And you have imputed this verse into the mouth of the Lord Ayappa because he's not here. Such kind of the words could be imputed by the astrologers. And that too in 1985 only.
9 judges. What was the controversy which was brought
The
to this court?
controversy is
and
regarding the
by
belief.
This court is the question.
Therefore, I am saying, what
We
is
are
the belief?
repeatedly asking our case.
Therefore, I am asking you, what is the
What
belief?
was the controversy brought? Why was it entertained? What are we as 9 judges doing now?
Kindly see page 82. Whatever their rights, what their ceremonies, what their beliefs, I am adhering to. There is no problem like that.
Mr. Gupta, we understand your argument is Lord Ayappa has been made to believe to be a brahmachari, not by any religious practices, but at the asking of some astrologer. That is one your argument. Second, your argument.
Not my argument, but has been reflected in the Kerala High Court judgment. sir.
Naturally, you are heavily rely upon that judgment, so therefore it's
Judgment
your
I have
argument.
relied.
You are relying upon that.
How the belief has been created.
Second, your argument is that if the women can climb to Mount Everest, why not Sabri Hills? That is also your argument. Now we proceed, now you can come to page 86, para 59.
No, miss. This is just 1 minute. I'm a placement.
Where you have explained the expression or any section thereof.
Section thereof, my lord.
Please.
Yes, sir. This provision confers right not upon religious denomination, but also upon section of said religious denomination. The expression or any section thereof. Thereof is very important. It conjunctive with the expression religious denomination. It cannot be separated. So that section of the person must be belonging to that religious denomination. But this is not the case which is applicable in Sabarimala case, because 4 to 1 it has been held, it is not a religious denomination. The expression or any section thereof is conjunctive with the expression religious denomination and does not exist independently. Any section thereof means that they must be belonging to some religious denomination. The expression thereof connects it to the religious denomination. Otherwise, the constitution makers would have employed the expression any section of society, but they have not employed section thereof, which would have widened the scope of Article 26A to 26C. The aforesaid right basically confers following rights. Right of religious denomination or any section thereof to create any religious institution for both religious and charitable purposes. Right of such religious denomination or any section thereof, so created to manage its religious affairs. Right of religious denomination or any section thereof, so created to own, manage property. My lord, just for a moment, my lord, I can just pause for a moment, my lord. Why there was a need for this Article 26B? Unnecessarily. When you are giving the freedom of religion to everybody, it should also be given. The religion was different. The expression in A, what it uses, religious and charitable. That what Indra has also stressed upon it. The expression, that is very important. And, not or. Why? Because large number of the religious charitable institutions are imparting education in different parts of the country. There is a DV trust. There is a Sanatan Dharma trust. There is a Arth Samaj trust. There is a Vivekanand trust. They are running hundreds of schools, not from today, from the starting of 19th century. They have set up. Now, all these religious and charitable institutions, the constitution makers were keeping in their mind that they should not be interfered with. The moment you will start interfering into all these aspects, it will create a lot of problems. So they have carved out separately religious denomination. Okay, some powers should be given to them. But don't make them, this is not subject to judicial review. You cannot touch 32, 142, 226. This, I don't think that this should be even the issue in the area of the issues.
We appreciate that part. Para 61, in fact, you explained.
Yeah.
In para 61, you have explained this aspect. You can read that
Just 1 minute.
few lines.
Kindly see. I'm a place. This page 88, para 61. The state's power is not confined to Article 25(2), but also to every individual denominational and non-denominational right which is subject to public order, morality, or health. Thus, both Articles 25, 26 would be regulated under the expression subject to public order, morality, or health. Moreover, a state under Article 25(2)(a) can to regulate any aspect related to religious practice in any such religious institutions. The massive power was given by constitution makers to the state after experiencing from conflicting judgments delivered in Australia on unique Jehovah Witnesses. There is a famous case, Malad, that has been mentioned several Supreme Court judgment, and the judgment delivered by American courts over compulsory enchanting of national anthem in classroom, as stated in Shurur Mat case at page 1028. May I read this one? It is to be noted that both in American as well as in Australian constitutions, the right to freedom of religion has been declared in unrestricted terms with or out any limitation whatsoever. Limitations, therefore, have been introduced by courts of law in these countries on grounds of morality, order, and social protection. And adjustment of the competing demands of the interests of government and the constitutional liberties is always a delicate and difficult task. And that is why we find a difference of judicial opinion to such an extent in cases decided by American courts where questions of religious freedom were involved. Our constitution makers, however, have embodied the limitations which have been involved by judicial pronouncements in America or Australia in the constitution itself. And the language of Articles 25 and 26 is sufficiently clear to enable us to determine without the aid of foreign authorities as to what matters come within the purview of religion and what to do. Now, Mala, just for a moment, Mala, like I say, in America, the situation was entirely different. American Constitution is 200 years back. And in American Constitution, the First Amendment, which gives the right to the religious that you can also practice, that they have provided there. But at that time, the situation was entirely different. We have gone far away from there. Therefore, I wanted to read certain extracts in the prohibition of sati bill. That was very important, but your lordship has said, just skip over that one. Because that was the same mindset, which is the mindset of the other side. There is no difference between the two. I would have proved it what argument they have made before the Privy Council. Same argument which the other side is making the arguments. And I've quoted those arguments before the Privy Council. And your lordship can look into it, that what arguments were placed before the Privy Council committee, that how they have tried to protect it. And there was a resolution which has petitioned the Privy Council against that bill. And in that resolution was by the Hindu Raja, and some 53 people were there. They petitioned against this prohibition bill before the Privy Council. And they also passed a resolution that whosoever will be supporting this bill whereby sati has been prohibited, he will be excommunicated.
Alright.
This was a resolution on the court.
So what do you say now, interplay
Now,
between
kindly see.
25 and 26?
Para
Interplay between 25, 26, paragraph 63.
63. Interplay. Interplay, there is a lot of arguments I've already taken. Some I've already argued. But your lordship,
I think you have summed up those arguments very well. Anything new you want to point out here?
Well, almost the arguments once the other side has already accepted. Well, I may read those one, no problem. But the thing is,
Those have been
this,
argued
that
well.
it will be a repetition. Essential religious functions of religious denomination. They are the Shirur Mutt case, that Attorney General opinion that already been
That's
read by
it.
several people. I don't want to trouble your lordship on that one.
So
Therefore, I was
page
saying that
96, I think.
now exclusionary practice at page 96. Kindly see, that is very important. Because this whole reference is with respect to the exclusionary practices. Whole reference. There are 2 or 3 cases the bench has got it, and making it the ground reference was made. So I'm very touchy about the FGM. I say that any kind of bodily mutilation, whether it of male or whether it is of female, not only male, not only female, male also, because he's a child. And you are subjecting to some kind of the case. This is a century-old practice. In all, not in the Christianity, but 2 Abrahamic religions, coming from Adam and Eve, and 2 Abrahamic religions of Judaism also, this practice was practiced, and that has been followed in the Islam also. It is not in the Islam as such. It is not the essential part of the Islam, male circumcision. But it was already going on. So nobody has given thought to it. And whenever any reformer will come out of it, then few people may just start crying that no, this is against my religion. It has nothing to do with the religion. There are so many things. Like Urdu is not the religion of the Islam, but still some people, they believe it like this, that Urdu is a religion of the Islam. It has nothing to do. So there are certain customary rights which bodily affect. Therefore, the main jurisprudential issue which was in the Satyapatha was what? Which will prevail? State or religion? State says, this is my right. You cannot murder anybody. And practice says, no, this is my right. Religious people say that. What the William Bentinck said, you have not consulted well the Hindu people. Then what the William Bentinck said, that you kindly postpone it. Then the William Bentinck said that I will be failing in my duty. Kindly mind the verse what he has said. I will be failing in my duty. I will not be pardoning myself if I delay the execution of this bill even for one single day. Because as per the British Gazette, there used to be 3 or 4 sati every day. So he said that I will be blamed for those ladies, those who have been burnt alive. And not only in this Bihar, this is the position. In the Bengal, this sati pratha was there. This bill was confined to the Bengal as such. In Punjab, after 10 years of this abolition, because this abolition was confined to the Bengal, when Raja Ranjit Singh died, in his funeral, 4 princes and 7 lady slaves. He had 53 wives. 4 princes and 7 lady slaves were burnt alive. This was a ghastly crime, and the same argument other side is giving. There is no difference in the concept. Same logic. This is my religion. Don't touch me. This is all Raja Ram Mohan Roy and so many people, they have come out.
And health is there.
This court has to be very careful so that the other side may not have this view that now they can extend up to the Home Secretary, and at any moment of time this can happen. Well, I will give the one example which I have not read it, my lord. What your lordship must have heard about the Epstein Island. What is this? Is it a religious place or it is a sex orgies case? It is a religious place. I have not read that paragraph. Your lordship has said to skip over that. It is a religious place. It is a St. James Island where there is a temple on the top of it. And there is a Baal who was earlier used to be regarded as God in the Judaism. And ultimately later on, he was defeated by Al-Jihad. And then he was taken as to be Shaitan. And he has been mentioned 900 times there in the Hebrew Bible, Old Testament.
All right. Proceed further.
So kindly see that these kind of the practices will erupt because it is a very recent one. So this court has to be very careful while treating upon the religion. Never give such a liberty as to exclude the judicial review.
Article 25(1) itself says, subject to public order, morality and health.
Well, morality is different.
Yes.
Well,
There are
morality has
these riders already.
a crime is a crime. And that was the case before the Sati Pratha. That's what the William Bentinck has said. He has said that this is a state subject. And religion used to say, no, this is my religion. This is my subject. And he has asserted his right of this. And I've also given a tug of war. How there was a James II, he fought with the Pope. How Cromwell has executed the Charles I and then brought the democracy in this country. If you read the history I've given in my written submissions, how there was a tug of war between the Pope who was sitting in the Rome. He used to give the dictates to the kings, all the kings in the Europe. And then James II revolted.
All right, we'll go through it. Now proceed.
Kindly see my written submission on this issue. Because this is the tug of war going on. And whatever we have achieved till today may not be undone, my lord, only in order to protect a few fundamentals. Because we have gone far away from there. Civilization is moving forward. What we used to be the barbarians, not only in one religion, in every religion. You read the Yajur Veda, you will find a Horse Veda, you will find a Purush Veda. What is this Purush Veda? Kindly read the English translation by the Griffith, who has translated these Vedas. What he has written. He was told that these shlokas are going to control so many satellites, etc. When he translated it, he has learned the Sanskrit. He read the Sanskrit for that purpose. Because some people were misleading him on this issue. Then he read himself. And then regarding the 5 stanzas, he says that these are so vulgar, my Christianity does not allow you to translate. and one Muslim scholar has translated it and uploaded it. So kindly see, and then ultimately he came to this conclusion. They were nomadic tribes. They were nothing. There is no. They were nomadic tribes traveling from there, and they came from Mesopotamian regions. They were called Matanis there. If your lordship will trace out the history, they were Matanis there. And they were driven out by the Assyrians. One person has gone there to the, one group has gone to the Germany. They also called Aryans. And one group has come here. It was a very martial community which has discovered the Rath. Rath was a new invention made by. And there is a proof that how they migrated to India, because there are certain clay tablets found in the Egyptian museum. It is mentioned that in the name of the Varna, in the name of the Indra, this treaty is executed. These are, Vedas have no archaeological basis because they were Shrutis. They were being chanted generation to generation, from father to son and son to. No archaeological site is there. But when these people, including me also, I am also Aryan. So what we have come from there, I'm not talking about the South Indians because they were driven out of the, as per my view, Harappa and Mohenjo-daro, they were there. And in Mohenjo-daro, Harappa, there was no religion formed till today. And it was the best civilization without any religion. And the kind of the city they have developed, that city you will not find anywhere in the Europe or any part of the world.
So we will hear
I'm
you
sorry.
on some other occasion as a historian.
Also.
We will hear you on some other matter as a historian. Right now, you please confine to only legal submissions.
Now kindly see,
The light
uh,
can give that.
now page 98. 98. There are three phases of the women where the discrimination was made. Three phases. The first phase I have dealt at page 98. When as soon as the child is born. Page paragraph 70. That this practice of FMG is not limited to only Daud Vora community, but as per WHO report dated 31/1/2018, more than
We'll go
200
through
fiscals. Page 98.
We have seen that, and we have seen the World Health Organization issues which you have raised in para 71.
Para 71.
We have read that also.
Then para 72, in order to appreciate the efforts made in the.
You may come to page 104, Article 39.
I'm correct.
That's a new argument.
I'm grateful, madam. I'm grateful. 104. Certain principles of policy to be followed by the state. Article 39. Indian female genital mutilation is not only unconstitutional, but in India there is no such problem like that. Second phase, 105, if you like.
There you are relying on directive principles.
Page 105, second phase of women life. Now, when she gets a puberty, as it is in the case of the Sabrimala. That is her second phase. First, in the child, she is subjected to circumcision. Then as she grows, now puberty has come. The whole generation today is only because of the womanhood. And what is under challenge is the womanhood, not the women.
Mr. Gupta, at page 105 and particularly 106, whatever you are highlighting is now constitutionally declared unconstitutional through Article 17.
105
And
should
through other-
be para 77, if you
through other part 3 of the Constitution. So we need not to unnecessarily refer to these things. Huh?
So these are the practices, since these were referred to, your lordship.
Yes.
So your lordship has to make certain observations, which my lord was asking, that you come to the point. Now the reference which is being made is not to Sabrimala case. Reference is made because of these cases. And you took the alibi, the court took the alibi. Well, these cases are also there undecided, and therefore what cannot be done directly cannot be done indirectly also.
So we can come to page 110,
Yes.
issue number 6.
I'm coming. I'm grateful, my lord. See issue number 6. Sections of Hindu, I've already stated, my lord. Page 110. That so far as issue 6 is concerned, relating to scope of expression sections of Hindus appearing in Article 25(2)(b). It is subject that Article 25(2)(b) was codified in the light of various ill practices practiced in Hindu temples. It does not exist independently, but is dependent upon affirmative action of a state. However, while framing any law for entry of any sections of Hindus, the law has to be constitutionally valid. In Sabrimala case, the state of Kerala exercised power under Article 25(2)(b), allowing entry of every sections of society in all Hindu places of public worship, including Sabrimala temple, by passing Kerala Hindu Places of Public Worship Act. But in exercise of powers conferred by Section 4 of said enactment, while framing rules, namely Kerala Hindu Places of Public Worship Authorization of Entry Rules, 1965, it provided under Rule 3B that women were not allowed to enter temple premises at such time during which they were not by custom or uses. This is what I have challenged. Belief I have not challenged. Belief is different than the custom and uses. This I have challenged. There could not be any such custom like this. And the writ petitioner challenged this Rule 3B, which has been struck down 4-1 this year. Next question arises whether the expression all classes of sections of Hindus occurring in Article 25(2)(b) includes religious denomination protected under Article 26. It is subject that Article 26 represents one section of society running a religious denomination of any religion which is part of the general expression, all classes or sections of Hindus. It has been so held by Constitution bench in Devaru case. Well, I am just skipping over that one. Then the issue number 4, constitutional morality. Constitutional morality is the law of the land today, because it is decided by the majority of judges. Chief Justice Deepak Mishra was delivering the justice on behalf of Justice Ajay Khankar also. And Chanchud, Justice Chanchud has given a separate verdict. So there are 3 judges. So it is a majority judgment.
Yes, that's understood.
And it was also followed in High Court of Tripura.
You can come to the most difficult question for you.
One
And your
minute.
street anchor is issue number 7.
Yes.
No, I am coming to 7. But one thing I may just clarify, because Justice Sanjay Karol, he was the Chief Justice then in the High Court of Tripura. There was a ritual of animal sacrifices. I have quoted that question. You also can read it from my written submissions. And he has narrated the entire story. And after following the Sabrimala case, then he writes that these animal sacrifices are not the essential part of our religion. So what my Solicitor General was objecting to, this will immediately erupt after your Lordship judgment if the moment your Lordship judgment goes a little bit in the favor of the religion. One has to be very careful in that regard. Now kindly see, Manoj Narula has already been argued. Now issue number 7. Well, issue number 7, my younger sister also wants to say something because she is Bhakti Pashricha. And there was, just 1 minute. My Lord will give that time. 5 minutes kindly allot her so that she can also speak, because this is.
We will hear you, madam, but please have patience.
Given opportunity, I will be addressing.
Okay. So she is very eager to. There was a lot of pressure, allurement. She was removed from the central panel. And apart from. Just.
These submissions.
Acha, acha,
Not
that's all.
these.
Okay.
Lordship, I will
I'm,
put my submissions back.
okay. No, so far I've also got the life threatening, but I did not bother. And giving the life for this purpose, I do not mind. And I'm ready to die. So these threatenings were there. Then Chief Justice Deepak Mishra was very annoyed. You cannot stop the judicial process by such kind of the threatening. And he has provided the police protection. I refused. And to the president also. Oh, no, his fault. No, Shah Ali's fault was nothing. He was simply a mainlander president. He was not knowing anything about the Sabrimala, as my ladyship is right. Whether you were knowing anything about it. So far as Noshad Ali is concerned, he was not knowing anything. But an impression has been given, everything has been engineered by a Muslim fellow. And he started getting threats from all over the world. Then Chief Justice Deepak Mishra was shocked. What is happening? This affidavit has been sworn in by the Bhakti Pashricha. He was General Secretary. Vakalatnama is also offered. Noshad Ali has nothing to do. He was telling me, Mr. Gupta, what has happened? I was not knowing anything about it, how this has happened.
So he has ensured that there is no delay by note.
so far as she will address on this issue, so far as lazy is concerned. I know so many people, if you will go to the any tourist spot, in the wayside, if somebody tells you that there is a one temple and very famous temple, you just divert your car there. What is the rituals are there? Nobody knows about it. But even then you will turn your motor cat there. Okay, just let's see what is happening. Somebody has told you go to the Bhutan, this is there, you go there, some Devi is there. So now I have started avoiding all these things, but at one point of a time, my family members, my wife will also say, why don't you go there? Just it is very near to your wayside. So we never go to the temple. What is very peculiar about it? Simply this, Hindu religion is very liberal, very liberal religion. You cannot even define it. Whether you put Sanatana or you put Hindu, you cannot define by any expression at all. Or I can say that Hindu religion is the abstract of all the religions. Whatever is left, that's the Hindu religion. You come to me, you will get the solace. If you don't agree with the tenets of Islam or Christianity or anything, Judaism, you come to me. So this Hindu religion is so liberal. So it has a very contrasting ideologies. It is getting rid of violence day by day. From Vedas, which has started, Buddhism has come, then the Buddhism has been driven out. Then again, so many things have happened in the way of life. Therefore, Hinduism is called the way of life. It is not a religion. It is only a way of life. What way of life you are adopting to? That's all. There is no fixed rules, etc. So this temple is concerned. My ladyship is right. You do not know anything about the Lord Appa. Of course, I do not know. But this much I know, that it is a Hindu temple.
What we are saying, Nauzad is a very smart guy. Because as you rightly said, see, he did it here. Had he made this attempt to clean his own house, he would not have been available to file this PL. But it.
Repeat it, please repeat, brother.
Yes.
What is it?
If you had made attempt to put his house in our own house in order.
No, Shah is a name lender, president. He did not sign Vakalatnama. He did not sign
He had
affidavit.
no interest in the matter.
He does not have any.
Then why was it entertained by this court?
No, he was getting threatening.
No, where was the resolution passed by the association?
No, I've already.
Not a resolution.
No resolution.
The litigation has been
For
ignited.
every case, we have to pass a resolution.
Of course, sir.
Yes.
General body is meeting every day in Galanchawar.
Not general, your committee, sir. Your
We have
committee.
simply to decide, there is no such law that there has to be some resolution. Once the
Have
president
you annexed
or
the
the
bylaws of your association?
in the bylaws,
Have you
in the
annexed?
provision.
Have you annexed it?
No, I am not an expert. So in the bylaw, but now we have gone too far because once Chief Justice Deepak Mishra made it very clear, even if you intend to withdraw this, I am not going to allow you because it is a court matter now. And I am assisting your lordship.
Mr. Counsel, senior counsel, since you are referring to the learned former Chief Justice with great respect, rather than ensuring that there was security provided to the advocates, he could have ensured that there was no need for a security threat at all by not entertaining this petition. With great respect, we are saying it.
Mr. Gupta will tell you, we heard it graciously. Just because we are sitting in a constitutional court, we don't want to express certain things. Probably the fact that it has been filed by the petitioner will have an impact on how we should look at these things.
No, my lord, I am coming to that particular issue.
All that we can say is, without expressing much more than this, it's a clear abuse of process of law.
Coming to that issue, how the PIL has developed. For your lordship's information,
They were telling you this,
I am the first lawyer.
nothing else.
I may be credited with this one.
Yes.
I filed the first PIL in the field of the environment.
Your best argument can be, Mr. Gupta, that it was de facto a suo motu petition, de jure filed by an association.
Naturally.
Yes.
And I think
But
that's all
since
your
that-
PIL.
No, but since that stage is over, and it is a court matter now.
I think you should understand the realistic assessment made by my lord, the Chief Justice on this case. Please realize it.
Now we can proceed further.
Now kindly see, Constitutional morality.
So this is the article you relied upon, page 121. And we entertain PIL based upon this kind of document which should have been thrown outrightly in the dustbin. A news item that some
Questions which can be addressed by me, Lordship only. Only bearer knows where the shoe pinches.
law will take its own course. If somebody had committed a misconduct, the court should have directed that try him, hold a day to the trial and make sure that he is convicted.
Lordship, may kindly reserve these questions for me. I will address all these.
Yes, we will hear you. We are only on talking of the locus which is generated on the basis of a news item regarding a criminal misconduct committed by someone. The court should have taken suo moto, directed day to day trial, make sure that if he is guilty of this offense, the law must take care of it. That's all. How does it, this article give you a cause of action to rake up the issue, ultimately which is adjudicated?
Well, may I address your
It
lordship?
is easy to get articles written for the sake of filing PILs.
Well, on the PIL concept, as I will told. okay,
We are very much aware, we have entertained PILs when we were in the High Court. We are entertaining PILs here for genuine causes. For getting relief to the public who are in really need of it. Not for articles being written in the newspapers, which are the basis of PILs entertained by this court,
Sister, this is not even in an article.
whatever it
It's
is.
a misconduct committed by an individual. Whose
Articles
religious
also.
position he might be holding. A misconduct is misconduct. Nobody can be above the law. If as a priest he had committed some offense which was under the penal law an offense, the court's action should have been to make sure that if he is guilty, he must be brought before the law. That's all.
Well, the PIL concept, when a Hussain or a Khatun case, that's the first case.
Every day, my lord, the Chief Justice receives hundreds of letters.
Naturally,
Can all those be converted into PILs?
I appreciate on that particular
Yes.
point. But
I
that-
would be addressing the background because I know how it was filed, so I would be addressing that background.
Yes, yes. Well,
But one thing is there, PIL is not an adversary litigation. If you are interested in any subject, you cannot,
there you are right. Absolutely.
you have to
right.
be disinterested. Otherwise, the court will say you have got the pecuniary pecuniary interest in this particular matter. So PIL, once the Chief Justice Deepak Mishra has made it very clear, it is a accepted norm. Once the court takes cognizance of the PIL, it is not a matter of the parties. It is purely a matter of the court. Court can replace the counsel, court can replace the petitioner, everybody. Because the court is only concerned with the issues which are
We don't
raised.
want to go into this debate.
Because there-
PIL can also be an adversarial litigation. Ultimately, there will be parties against whom, suppose the court want to strike down certain things, there will be parties affected. They will always take it as an adversarial litigation. There is nothing wrong in that.
Adversary
PIL
litigation,
can
I think,
also, if ultimately can have consequences which are adversarial in nature. But there is nothing wrong in that.
adversary litigation, I can understand in some matters, sir. There could be the adversary litigations. But adversary litigations, not in the sense that this court will satisfy the writ petitioner in that matter. The court has itself to see whether such and such provision should be struck down or not. So in PIL, once the court takes a cognizance, it's a court matter. But that's my
The only
submission.
difference, Mr. Gupta, is between an intermedular and a bona fide PIL.
Now, Malak, one aspect I have forgotten, Malak, page 111. There's a constitutional morality that I was addressing your lordship with that this is a judgment by the majority in the Sabarimala case, and it has become the law of the land now. It has also been followed by Justice Sanjay Karol when he was the Chief Justice of the High Court. That judgment I have also quoted it now. Constitutional morality. This is not the issue which is related to the writ petitioners as such, so I can speak even otherwise also. Constitutional morality is a concept which differs from person to person. Constitutional morality cannot be split into constitutional and morality. Morality is being taken by the Justice Chandrachud In the Sabrimala case, it is entirely different context. That is immorality relating, connecting it to the adultery or something like that. Constitutional morality is a one expression. It has nothing to do with the expression, but in the issue which has been framed where I was not invited, my lord. In the issue, they said the concept of the morality and constitutional morality. What constitutional morality has to do with the morality as such? If I say anybody is intellectually dishonest, I am permitted to say. Better if I say you are dishonest.
All right, thank you, Mr. Gupta. Anything else?
Thank you.
Anything
Thank you.
Now,
We heard you.
regarding this issue number 7, my learned sister will address.
Yes.
Let first my learned
All right.
brother who I
We heard you.
promised him.
Thank you.
I'm
Thank you,
grateful.
Mr. Gupta. Thank you.
I'm great.
Only one thing we want to say by way of a reaction. PIL, public interest litigation has now become private interest litigation,
Publicity.
publicity interest litigation, paisa interest litigation, and political interest litigation. All are called PILs. But
Personal-
we entered only real and genuine PIL.
Yes, it is being misused. It is being misused. Therefore, a lot of guidelines have been laid down in the Supreme Court rules
Not being,
and in all other high court rules.
not being followed.
The court has to be cautioned on that particular issue that whether it is a misuse of PIL, there is some oblique motive. But here the ladies cannot have any oblique motive that they want to enter into the Sabrimala temple. So they could not have any malevolent intention behind it. Except this, they were shocked when this publication has come that the tantri has been found in a brothel. So this article was also there on the face of it. So these lawyers are concerned about it. It is a place. In regard to the law, I mean to say Lord Ayappa, the duty of the Lord Ayappa. Lord Ayappa would also like it that somebody should go to the court. How this tantri is sitting in my sanctum.
Thank you. Thank you,
sanctuary.
Mr. Gupta.
I'm
Thank you,
grateful,
Mr. Gupta.
Lord.
Thank
I'm
you.
grateful in spite of my all inability, my lord, and having physical handicaps of hearing and
Thank you very much.
I'm
Thank you.
grateful.
May it please your lordship.
Should I address now?
After this, if you maybe should can.
You can.
Five minutes.
Yes,
May
Mr.
I
Kamba.
just wait a second? Lord, your lordships and we have heard many arguments, many submissions, much wisdom, erudition come from all those in this court, particularly from your lordship. And I would start by saying that we are all trying to resolve a problem which affects all of us and our whole country. Therefore, it should be a collaborative effort rather than a confrontationist. And I would immediately say that every view that has been expressed, whether one agrees with it or doesn't agree with it, is sincere and bona fide towards that end. It's a monumental task. Let's not belie the task that is before your lordships today, because your lordships, in answering these 7 questions, will have to think or contemplate of a myriad different situations to which they would apply. I, in fact, agree with several submissions of the learned Solicitor General and my dear friend, Mr. Subramaniam, and I'm going to point that out. And on certain areas, I have a different view, which I'll place before my lords. But I believe, and I'm going to start with this, only for context, because I understand your lordships are not going into any facts. I'm not getting, but only to give a context. I've prepared a very short, brief factual note to explain what the matter in which I appear is, because it will give rise to certain issues which perhaps have not come to the fore before your lordships. And of course, the cardinal issue in that case is not part of the 7 questions. I must immediately start by saying that, because if my lords have my brief,
Whom are you representing?
I represent Mrs. Gulrukh Gupta in SLP number 18889 of 2012.
Petitioner of that.
Who is she? She is a Parsi Zoroastrian lady. She always was and remains a Parsi Zoroastrian lady who married Mr. Mahipal Gupta, a Hindu, under the Special Marriage Act. Now, her parents are residents of Valsad in Gujarat. It's a small town in Gujarat. And one day she found that another lady in her position was being denied entry to certain places of worship, including for the funereal rites of her parents. So she was concerned that the same thing might happen to her. So she filed a writ petition where she sought a prohibition against the respondent trustees of a public charitable trust that I continue to be a Parsi Zoroastrian. I have not forsaken my religion. I am a devotee. I am a believer. And just because I have married a Hindu, that is not a crime. It's under the Special Marriage Act. Please don't stop me. And she appealed to the court to restrain them. Now, in that context, the Gujarat High Court has decided, and that's the issue in that case, that there is a deemed conversion, that even if you get married under the Special Marriage Act, a woman is deemed to be converted to the religion of her husband. She has no independent religious identity, but her religious identity merges with that of her husband. And therefore, without any act of conversion, change of belief, any ostensible act whatsoever, she is deemed to have converted. Now, of course, that will be argued in that particular matter. That's not an issue that arises before your lordship. But please consider the ramifications of this. Today, every anti-conversion law is based on conversion by inducement, allurement, force, fraud, undue influence. All that will be wiped out and rendered nugatory because the very act of marriage itself will be a deemed conversion. So it's a very far-reaching judgment. It doesn't apply only to Parsi Zoroastrian ladies. It will apply across the board. And in my respectful submission, with due respect to the Gujarat High Court, the dignity of women is seriously undermined. This would violate every right under 14, 15, 21, 25. Now, I've set out in my note on page 2 that this is a trust run under a trust deed. It was settled by someone who left money for this. The trust deed, para 5 of my factual note, I've just extracted portions, is for the benefit or upliftment of the Zoroastrian community of Valsad, for the spread of the Zoroastrian religion, and for education, help, and to help poor Zoroastrians. It has no prohibition that if a Zoroastrian intermarries, he or she is not entitled to the benefits of the charity. So one of the issues that might arise is that when
In the Gujarat High Court, when the trust opposed the writ petition,
yes,
was there any specific plea taken by the trust that the religion prohibits or in her
there was
conversion?
there was a plea which has not really been gone into by the Gujarat High Court, and the material produced before the Gujarat High Court did not bear out this. In fact, the finding which I've set out in para 6 of my note belies that there was any such prohibition in the religion. Before your lordships, now in the Supreme Court, a whole lot of further affidavits, etc. are filed, which in my respectful submission still do not bear out that the religion prohibits it, but that's a matter to be argued before the relevant bench. Would my lords just see para 6 of my note? I've extracted 2 findings of the Gujarat High Court in this short factual note. Page 2. The majority judgment found 2 things. First, that there is no prohibition to the petitioner or any woman who is born Parsi Zoroastrian, married to non-Parsi, for continuing to profess Parsi Zoroastrian religion. That's a square finding of fact in the impugned judgment. And the second finding of fact is, we are not shown any material as to how entry of a non-Parsi to an Agyari, which is a fire temple, for offering the prayer would violate the integral part of Parsi Zoroastrian religion. I believe this position remains untouched by even the further material that has been produced, but that's a separate matter. In fact, that further material, when we argue the actual case, we will be able to show ex facie, even on the material produced by the other side, that it bears out no such principle under the Zoroastrian religion that women are to be excluded for intermarriage. Why? For a very simple reason. None of the extracts say that. In fact, for over 100 years or more, there is an unbroken practice that Parsi Zoroastrian intermarried men and their children are freely permitted entry. So it's purely a case of discrimination. Because if there was any such prohibition in the religion, it would then be for both. It would not be for one or the other. No material, I can say with the greatest of responsibility, produced by them shows that this prohibition attaches only to a woman. Nothing has been produced. Even in what they say is the Zoroastrian religion. In fact, the Zoroastrian religion, my lords, may not be, it's actually an offshoot of a Rigvedic religion. People don't maybe know this. Most Zoroastrians don't know this. And it's a Rigvedic religion, but it is the first monotheistic religion ever. And all the Abrahamic religions take a lot of their theory from the Zoroastrian religion. Heaven and hell, day of final judgment, good and evil, all these are Zoroastrian concepts, all then later taken by other religions. But the genesis is the Rigvedic. In fact, the old Avestan language is almost 95% akin to old Sanskrit. That's a different argument for a different. Now, one other thing about Zoroastrianism, and we'll be going to, is it has been described by great scholars, including the great Professor Zeno of Oxford, that it is a religion of free will par excellence. It's a very forward-looking religion. So it would be almost impossible to find this in scriptural texts, that because you intermarry, a lady is cast out of the community. It's just, but that again is, I reserve for the main matter. I'm not troubling my lord with all that.
So marriage is the basis of discrimination.
Yes.
Vis-a-vis only a lady.
Only a lady. And a deemed conversion, only a lady. A man can marry outside, no deemed conversion, he continues to be Parsi Zoroastrian. And his children are Parsi Zoroastrian, but not so a lady. And this is a man-made, pardon the expression, a man-made imposition on otherwise a very progressive and a great religion. A great religion. Now, there was a leading case in Bombay, which I've just referred to briefly at page 3. A division bench of the Bombay High Court way back in 1908, which heard the evidence of almost 60 witnesses, including priests, religious scholars, everyone, and came to the conclusion that the Zoroastrian religion not only permits, but it enjoins conversion of a person born in another religion and of non-Zoroastrian parents. However, it found that although conversion was permissible, Zoroastrians, since their advent into India 1200 years ago, have never attempted to convert anyone into their religion. Now, this was the big, this is really what Article 25(1) is all about. Please consider, it's a remarkable story. A minuscule community, a minority amongst minorities, has survived for 1200 years with its religion intact, with many of its customs intact, borrowing customs and practices, of course. I may be permitted to say this, my lord, that this is really because of the tolerance and munificence of Hinduism. It must be said, and I will say it. In no other place in the world could this have happened. It's a remarkable thing, because there were small bands of Zoroastrians who went to other countries. They've been long wiped out. But for 1200 years. Now,
There is that story as to what that Parsi person told the king.
the high priest.
That it will be like sugar.
Sugar and milk. And
They will be absorbed.
precise, and to the credit
That
of
is
the king.
greatness of Hinduism.
Absolutely. And to the credit of the king, because again, many Parsi Zoroastrians don't know this. It's apocryphal. There's a Kisaya Sanjan, which may or may not be accurate, but we all sort of accept it as part of the law, that he imposed only 5 conditions. What were the 5 conditions? Please speak our language, give up your language. Please adopt our national dress. Please lay down your arms and till the soil. Please have your weddings after dark. And if we are attacked, please rise to the defense of the realm. These are the only 5 conditions. There was no condition that please don't convert. But voluntarily, the community has decided not to convert, and that is a policy which has stood the community in good stead. Therefore, this is a forward-looking community, and Parsi Zoroastrian are often conflated terms. Parsi is the race or community. Zoroastrian is the religion. So you can have a Parsi Christian, you can have a Parsi Baha'i, you can have a Zoroastrian who's not a Parsi. Parsi denotes coming from a region in Persia, Pars. But often it's mixed up. And one last thing, before your lordships rise, and then of course I'll come to the questions. We've set out at page 4 that there's no such uniform practice even amongst Zoroastrians in India. Please see the para 13. The respondent trust itself under its previous trustees freely permitted intermarried Parsi women, Parsi Zoroastrian women, into the temples and places of worship. The Bombay Parsi Panchayat, from a very, very dignified and cogent address was made by a young lady advocate who said we must have autonomy, whatever the pain someone has itself passed a resolution way back in 1991 giving such free entry to intermarried Parsi women. That's the main bunch of Parsis happens to be in Mumbai. And we have placed material on record to show several Anjumans all across India. Delhi, Kanpur, Madras, Daman, etc. all permit entry. One or two, and particularly this Valsad one, suddenly under new trustees decided that never mind our trust deed, we will impose our personal views and predilections upon this. Therefore, that's the setting, the contextual setting. So the arguments there are going to be, this is certainly not a religious practice at all. It's a pure secular practice, it's not even a practice. It's not even uniform. So all those questions will arise. But to that extent, I'm going to submit to your lordships that some element of judicial review in these matters is necessary. One cannot take a totally hands-off approach. It's a classic case where judicial review will be required. I'll
So, after lunch, just refer to
Yes, certainly.
whichever you think that will have
May it please your lordships. Lord, your lordship, before the break had asked to see the judgment of the Gujarat High Court. Would your lordship like me to show it just now? May I show that?
Yes,
So that is found in volume 3.3.
volume 3,
3.3.
3.3.
3.3.
Yes.
Starts at page 1. But may I be permitted to go straight to page 53, which is para 26. It starts at 28.
Okay.
Sorry, starts at page 28.
15 running page.
Yes,
That's it.
page 28, running page.
Running page.
Yes, running page 26.
Especially with
I'm sorry, running page of the compilation is 53. The internal page is 26. Para 26 at page, internal page 26. Compilation page 53.
I think the judgment starts from page 32. That would be the internal page 5 of the judgment.
Yes, internal page 5, page 32. My lord is absolutely correct.
It's a 3-judge bench.
Three judge, but it is a 2-1 decision, majority and 1 dissent.
I see. One, there is a dissenting one.
One.
Dissenting is authored by whom?
That is by Justice Qureshi dissented.
Yes.
My lords, be kind enough to turn to running page 53, para 26. The reasoning is really contained there. In English common law, marriage implied the merger of personality of the husband and wife. In reality, it is meant that the wife's personality.
Just a minute, couldn't get that.
I'm sorry.
Where is in the red,
Red 53, page 53.
red 53?
Red 53.
Yes.
Where they start from, the line starts from?
Para 26 on
Para 26 page.
red page 53.
56. Wait.
Page 53.
Yes, 53.
53.
Just a minute, give me a minute.
In,
Yes, in English common law.
did you get?
Does my lord have that?
Yes, I.
My lord, does Ramanand have that?
Just a minute.
In the screen also it is there.
Yes, yes,
Yeah.
now good.
In English common law, marriage implied the merger of personality of the husband and wife. This is known as the doctrine of coverture under English law. In reality, it is meant that the wife's personality is merged into that of the husband. In view of this doctrine, a man could not grant or give anything to his wife because she was his dead self, and if there were any contracts between the two before the marriage, they stood dissolved on marriage. The freehold property of the wife vested in the husband, and during contract he had management of her property and take all the profits derived therefrom. Her personal property entirely passed to her husband, and he took it absolutely. Several things in her possession could also be taken over by the husband. Thus, the merger of the personality of the husband and wife meant that whatever property the wife had at the time of marriage and whatever she acquired later on belonged to her husband. This situation was remedied by the Married Women's Properties Act 1870, and English married women acquired the right to hold and acquire property. Please mark the next sentence. This English law doctrine was never a part of Hindu law or Muslim law. Although under Hindu law there is a doctrine of merger of personality, the wife being ardhangi of her husband and completed him, it may not know more than unity in a spiritual sense. No part of her property belonged to her husband. In fact, most of the stridhan she got was acquired by her at the time of her marriage. All gifts given to her at the time of marriage belonged to her. Even whatever they acquired during marriage belonged to her. Though in distress, the husband could use, but he had to restore it later on. Muslim law do not subscribe to the notion of unity of personality of husband and wife. Wife's personality and individuality are not lost on her marriage. She continues to hold whatever property he had at the time of marriage, and she can acquire property during the marriage. In India, neither Parsis nor Jews subscribe to the notion of merger of personality in the sense as in English law. But all such things are relatable to the right of the husband over the properties of the wife in her individual capacity, and they may not be mixed up with her personality known by the religion. In all religions, be it Christian, be it Parsi, be it Jews, the religious identity of a woman, unless specifically law is made by the parliament or the legislature, as the case may be, as per the religions, shall merge into as that of a husband. But this is just factually not correct at all, but I'll just read it. Such rights would be the rights other than those as may be available to a woman given by nature, and rights as otherwise specifically protected by express provisions of statute. It is hardly required to be stated that such principle is generally accepted throughout the world, and therefore until the marriage, after the name of the woman, the name of the father is being mentioned, and after marriage, name of husband is being mentioned for the purpose of further describing her identity. It does not mean that after marriage, the woman or a female will have no right in her individual capacity, which are otherwise guaranteed by nature or identified and protected by statute, or the right of a woman to live in dignified manner in society. But for the purpose of the present petition, we are required to examine the rights as that of the woman in the context of family, which originates from marriage of a husband and wife, or in other words, such family in contradistinction to the society at large. Even if the family is considered in its wider meaning, originating from the husband and wife, it may extend to their children, maybe son or daughter until they are married. After marriage of son or daughter, as the case may be, with any female or male respectively, for the purpose of society, would be forming their independent family originating from marriage of the said couple, as the case may be. There is one additional reason why the family should be identified as separate in contradistinction to society at large, because there has to be specific certainty for identification as per religion in normal circumstances for the son or daughter of the said couple who is born out of the said wedlock. If after his following a particular religion, and as observed earlier, if a man is married with a woman following another religion, in normal circumstances, it should be deemed that woman has acquired the religion of her husband after marriage. It is that the children born out of the wedlock will also be identified in society following a religion which was being followed by their father prior to the marriage. Test the situation from different angle. If a man born of A religion marries a female of B religion, and if for the sake of examination it is considered that husband and wife both continue to follow their original religion as were at the birth, then large number of ambiguity may prevail about the religion of their children. Such, in our view, would not be in the larger interest of society for the proper observance of the customs, traditions, etc. And therefore, we find it proper to observe that in normal circumstances, when the marriage takes place between a male and a female belonging to different religion, it should be presumed and considered that the woman after marriage has merged into the religion of her husband, and such will be the identity of their family originating from their marriage in comparison to the society at large, and such identity would stand extended to their children too. Same situation would remain in normal circumstances even for the man and woman who are married under the Special Marriage Act. However, the aforesaid, as observed earlier, would apply in normal circumstances unless it is established in any court of law after undertaking fact-finding inquiry that even after marriage, the woman has continued with her own religion, which existed prior to the marriage.
Rebuttable presumption.
I'm sorry.
Rebuttable presumption.
Rebuttable presumption. So a woman has to go to a civil court and get a declaration.
Yes.
No, under Hindu law, unless both the parties are Hindus, it does not become a Hindu marriage.
Precisely.
Therefore, if persons belonging to two different religions want to get married, special marriage
Special
is there.
Your leadership is absolutely correct. In fact, the Special Marriage Act of 1872 did not permit that because it was not open to Hindus, Buddhist, Jains to get married under that act.
Yes.
But that was amended, and finally, the current Special Marriage Act of 1954 permits that. It was, and the objects and reasons say it's precisely to get over that. So we are now importing all those old notions into a modern act. And therefore, 28 says, in fact, we have the Parsi Marriage and Divorce Act. Two Parsis can get married under the Act. But if it's one Parsi and one Hindu, then they have to go to the Special Marriage Act. And therefore, the onus is put on the woman, not on a man. A man can marry outside. He is not deemed to give up his religion, but a woman is deemed to, she has to go and get a declaration from a civil court. Today's constitutional democracy, we can't have a situation like this. Then if we go straight to para 32, I'm not reading every detail, but this is, I'm giving all the broad findings. Para 32, red page 62. A born Parsi woman, by contracting civil marriage with a non-Parsi under the Special Marriage Act, would cease to be Parsi, and she would be deemed and presumed to have acquired the religious status of her husband, unless declaration is made by the competent court for continuation of her status of Parsi Zoroastrian after her marriage. As I said, it is well settled. Parsi is a community or a race. It's not a religion at all. It's an irreligious term. Zoroastrian is the term. After the declaration is made by the competent court, after undertaking full-fledged fact-finding inquiry on the aspects as to whether after marriage she has totally abjured Hinduism, the community to which her husband belongs, and she has continued to remain as Parsi Zoroastrian, and whether she has continued the religion of Parsi Zoroastrian to gain any benefit, or whether the community, namely Parsi Zoroastrian, has treated her as a member of Parsi Zoroastrian for all purposes or not. But the whole obsession is that you would normally be converted, deemed converted, without any change of act or belief. But you might want to retain your Zoroastrian religion to claim some property benefits. It is not so. The lady just wants to continue her own religion, nothing more than that. Then if we go to para 56, the conclusions at red page 94. 56.1. Every religion, be it Parsi or Zoroastrian, be it Christian, be it Islam or Hindu, showers its benefits to all mankind. But the performance of various ceremonies by the believers or religious tenets is a different aspect. All the religious places, may be temples, mosques, churches, agyaris, are meant for the larger benefits of mankind in general and for the followers of the said religion in particular. Whether a particular place of worship is a public place or a private one would mainly depend upon its use by the public at large and also the belief in the society be treated so. After adoption of the Constitution, all religions are to be treated equally by the state. Article 25 of the Constitution guarantees right to freedom of religion to all persons equally as per his own conscience, and every citizen has the right to freely profess, practice and propagate any religion. 25(2) of the Constitution permits the state from making any laws for regulating or restricting any economic, financial, political, or other secular activity which may be associated with the religious practice. It also additionally provides the power to the state to make laws for social welfare and for reform for Hindu religious institutions, and such extends to Sikh, Jain, or Buddhist religious institutions. Then 5. The Constitution at the same time permits every religious denomination to manage its own affairs as per Article 26 of the Constitution. Of course, the same is also subject to public order, morality, and health. However, such right guaranteed under Article 26 applies to only integral part of the religious affairs, maybe as per religious tenets or otherwise, and not as per the belief or a mere tradition, which are not integral part of any particular religion. Hence, the conjoined reading of both the rights under Article 25 read with 26 shows that any citizen has the right to profess, practice, and propagate any religion, subject to the right of every religious denomination or section thereof to manage its own affairs in the matter of religion and other rights guaranteed under Article 26 of the Constitution. To put it differently, if any person wants to profess and practice any religion, the same is not so prohibited, but whether he or she should be permitted to enter a place of worship or not would be a matter of religion by a particular religious denomination or a section thereof. Rights guaranteed under 26 is to be enjoyed by any religious denomination, but it has to give equal treatment to every person professing and practicing a particular religion. Any action by any religious denomination curtailing such right of equality amongst the persons professing and practicing a particular religion can be said as violative of the rights guaranteed under Article 25 of the Constitution. And if such a right is violated, by any particular religious denomination or any section thereof, such person may enforce the right guaranteed under Article 25, but if against a private party and not the state within the meaning of Article 12, then before the civil court, and if such as such to be enforced against the state or its instrumentalities.
Civil court, she can claim against whom? Against whom she can seek a declaration that
So,
he is practicing.
later in this very judgment, and I believe that is the correct, 25 is what is known as a horizontal right. So it can be claimed against any institution that seeks to violate it. Therefore, in this case, she could claim it against a public charitable trust. And in any case, your lordships have held that a public charitable trust would be amenable to the 226 jurisdiction because there are public functions, etc. So she could claim it against the trust. It's a public charitable trust ultimately. So the trust deed would prevail. The trustees have to act in accordance with the trust deed and permit all the beneficiaries access.
She should seek a declaration that she is continued to be a Parsi woman than by practicing the Parsi.
I would put it with respect the other way around. There is no law that says you give
We
up.
want to understand the judgment.
So,
What do
yeah,
you
take
mean by this? She should
so the
she should
judgment.
question this practice before a civil court, or she should dispel the presumption before.
I am obliged. In fact, ultimately, this judgment has held that if anyone wants to set up a practice of exclusion,
Yes.
then they have to go to a civil court and prove on evidence that the religion contains that exclusionary principle.
Did she have children?
She has children, yes.
What are their status?
What are they? That's a different matter. The Bombay judgment again has held that children of Parsi fathers married outside are treated as Parsi, but not of Parsi mothers. That's a different judgment under a different, it's been challenged a lot in a different matter. Because that also is clearly
It's
discriminatory.
all some matter boiling down on common law of conversion.
Yes. And
That
what is
the merger of the women's
precisely?
personality into the man
Precisely.
upon marriage. So
The-
that is what
That is correct.
the.
What is known as the
But
doctrine of coverture
upholds-
under English law.
upholds with regard to merger of the woman in the marriage.
That's right.
And says that in the secular law, so perhaps the issue which may crop up on facts is whether the common law will prevail over a statutory provision.
Statutory provision. And a common law of
Even under
coverture,
the statutory provision, like in certain cases, or customs and uses in contract act,
that's right.
prevail over the contractual.
My lord, it is. But in fact, courts, and there are judgments which we cited, that this English doctrine of coverture is not even accepted in India under Indian law. It has never been accepted. In England also, it is now no longer the law. So suddenly, to revive it like this,
It's because the right of conscience under Article 25(1) is a right by birth and cannot be taken away by marriage.
I am obliged. That puts it absolutely correct. I'm grateful. That is the submission.
But a bigger question will arise, which in paragraph 59, the majority view
Yes,
relegates you to the suit
yes.
as to whether this right is traceable not in common law, but as a matter of essential religious practice to maintain the sanctity and the integrality of the religion.
My lord
That
is
is
right.
the question which has
That
been
is
kept
correct.
open.
That is correct, because that is kept open. The High Court has not gone into that.
The High Court,
Correct.
madam, rightly or wrongly says, writ is not maintainable against the trust. It's not an Article 12
That's-
entity.
No, the majority is held that it is maintainable. The dissent said it is not maintainable. I'll show that finding.
But it relegates you in view of the fact that it requires disputed questions to be decided. Whether the integral part of the religion or not, which they note in paragraph 59.
So if my lord is right, what the High Court has said is if you want to establish
If I
there is an
just
exclusionary
clearly
practice,
take out
then
the-
you must go to a civil court. But there's no presumption that someone who is born a Zoroastrian converts only by virtue of marriage. There is no such presumption in law is the contention. Whereas the judgment has said, though there is no material before us to show this, I'll show that finding also, there is an automatic deemed conversion. By virtue of this doctrine of coverture, which is the woman has no independent religious identity, it merges with that of us. which has never been accepted under our law.
We are not going to decide the judgment, but on a reading of it, it looks very strange for us to, whichever way you look at it, how do we support this? It is for the individual person to decide. See, as my sister put it, see, freedom of conscience followed by professing practice, and it is for the individual person to come. How that person will prove it against the world?
On a case by
Yeah, I
case
have given it up. I have accepted that I am going back. It's
My lord is right. Ultimately, it's a case by, in a given case,
Conscience
someone may
and
convert.
conscience cannot be static.
Cannot. Correct. So in a given case, someone may convert. There's no
Takes its
bar
color.
against that.
It takes its color depending upon the terrain it travels.
and it's for a person concerned.
That
you-
seems to be the,
all right, very well.
this is automatic.
We will not say anything.
So
because
my lords have
it's not
seen,
for us to say.
they have kept apart any evidence. They've said, in fact, there's no evidence. I'll show, that's para 58. They don't find that. I'll just complete reading.
But in this case, marriage as a basis of classification is discriminatory against women.
Against women.
That is the point.
Because the same principle is not applied to a man. Then the same thing should apply both ways. And that will lead to huge ramifications, not only for Parsis or Zoroastrians, but across the board. It will lead, this judgment in that sense has not got wide exposure, but it could lead to some terrible consequences. Lord, may I just go to page 97, read, subpara 10. While considering the scope of Article 26 of the Constitution of any religious denomination or any section thereof, it is to be considered by the concerned court or authority within the meaning of Article 12 of the Constitution as to whether a particular matter of religion or religious practice or belief are integral part of the religion, and such would essentially depend on the evidence adduced before the court or the authority as the case may be. However, if it is found that such matter is not an integral part of the religion, then the religious institution has no right or authority to curtail the enjoyment of right to profess religion by any citizen as guaranteed under Article 25. Now please see page 98, para 58. There are two very significant findings here. Read page 98, para 58. There is no prohibition to the petitioner or any woman who is born Parsi Zoroastrian, married to non-Parsi, for continuing to profess Parsi Zoroastrian religion. This is absolutely correct. However, while doing so, the religious denominations of the respondent, namely trustees of Valsad Parsi Anjuman, have curtailed her rights, contending that the petitioner, being non-Parsi, would not be entitled to enjoy such rights. The denial of such rights is on the ground that entry to Agyaris, where the fire temple is preserved, is not available to non-Parsi. In support of the same, materials are produced, but no material is brought to our notice by any authenticated religious tenet prohibiting entry to Agyaris by non-Parsi, may be male or may be female. Then they consider what evidence was produced by the Anjuman and say there's nothing in this.
Then why did they dismiss it? They could have, that is a finding they could have allowed her.
They should have, in my respectful submission, with
Yeah,
these
not-
findings, it hangs by the slender of slender threads, which is automatic or deemed conversion, doctrine of coverture. That's the only basis of this judgment. And page 99, just the last 4 lines of para 58, we are not shown any material as to how entry of a non-Parsi to Agyari for offering prayer would violate the integral part of Parsi Zoroastrian religion. Then 59. Further, the aspect may also be required to be considered as to whether a lady who is born Parsi until marriage, she has followed Parsi Zoroastrian religion after marriage, if she is not even permitted to offer prayers at Agyari, even in capacity as non-Parsi, whether such would adversely affect the dignity as a human being for offering prayers to the Almighty. On the aspect of entry to funeral ceremony at Tower of Silence, and for the right to have our own funeral at Tower of Silence, we find it is not possible for us to decide on the evidence available on record as to whether such religious practices prohibiting non-Parsi is an integral part of Parsi Zoroastrian or not. A detailed fact-finding inquiry may be required. So a prohibitory or exclusionary practice you will have to establish in a civil court on evidence. Otherwise, there's no presumption that you lose this benefit and as a beneficiary of a public charitable trust.
So it's like a violation of Article 25(1) right.
25(1) right is totally violated in the guise of saying under 26B, a religious denomination has the right to manage its own affairs in matters of religion. This is how wide sometimes it can be construed. Therefore, that balance has to be struck by your lordships. My entire submission is going to be not one doesn't prevail over the other. There has to be a balance struck. And that may have to be on a case-by-case basis. But a balance has to be sought for. No supremacy of one over the other. Then if we go to 61, at page 101.
In other words, on the basis of a practice, the belief is sought to be questioned.
Yes.
Question in the sense that you are a non-believer.
Non-believer. Here is a case of a devotee, a
Yes.
believer who wants to continue believing, and you are showing her the door. And that too in a community which is a dying community, such a small community. Today, informally, I may tell my lords, the statistics are that over 50%, last 3-4 years, over 50% of Parsi youth are intermarrying.
The discussion,
Intermarrying, whether male or female, both.
whatever discussion they made
Interfaith marriages.
in the judgment, whatever discussion they made, ultimately this practice presupposes and presumes that once there is an intercaste by interreligious marriage, you give up the faith in this under this.
Yes, my lord is right.
That's the difficulty.
And you do it under a statute specially meant to protect it.
It's virtually an excommunication.
It is virtually that automatic without going into the facts of the case. The excommunication matter
That is of
has
course
been
the
upheld on the ground that on religious grounds you can excommunicate.
They are challenging excommunication.
That may be, but not.
They are wanting.
That's a different type of a case.
Sinner's judgment to be.
But that's a
Their case.
that's a different case because that's a case by case.
Yes.
The following principles of natural justice only on religious grounds. Here it's en masse, automatic. You have to do nothing more. You're banned from professing your religion. Never mind if you're a devout Parsi Zoroastrian, out. Automatic. This is a very far-reaching. And then please see 61, page 101. In view of the aforesaid observations and discussions, we find issue number 2 as such would not arise, but if the action of the respondent is to be tested in light of petitioner being a natural Parsi Zoroastrian, having been married to a non-Parsi, and consequently having acquired Hindu religion after marriage, in absence of any declaration of competent civil court for her continuation to follow Parsi Zoroastrian religion and her status as that of Parsi Zoroastrian, the matter could be examined, and we have found it proper to examine, but it appears in the absence of any right claimed as non-Parsi, no final views. So the lady does not say that I've given up my religion, but I still want to enter. She's devout. She said, I continue with my religion. So they say, but you have not claimed on the ground that you are not a Zoroastrian and yet you want to come in, so we are not going to that. That's right, she's not, and even today she's not claiming that. She is a continued devotee. She doesn't want to say she ceased to be a devotee. Why should she?
Otherwise, in a Parsi Agyari, non-Zoroastrians are not permitted.
Are not permitted. That is correct. In India.
Yes.
In other countries they are permitted, but in India they're not. And that might also be a practice evolved over the years, as I mentioned to your lordships, even conversion, though it's a proselytizing or a religion that enjoins you to go out and convert. 1200 years, there are hardly any, if at all, recorded cases of conversion, and as a policy, conversion is not followed. But that's a practical policy, a very good policy, a wise policy, to my mind, at least. But that doesn't mean that when your men marry out, they and their children get the benefit. When your women marry out, they're shown the door. That's the sum total, even of this judgment.
That is what, if the children of Parsi father have the benefit of the Zoroastrian religion,
Correct.
that means it is by birth.
It is by birth.
Same thing will apply to the
It
date
should.
also.
It
She has got her religion by birth.
It,
Can it be taken away by marriage?
it should. Just one or two last paras. If we go straight to para 61, sorry, 61 I did, I'm sorry. Para 62, the majority has held that the writ under 226 is maintainable. But in the facts of the case, because of this deemed conversion, no writ was granted. Now, as your lordships know, the Special Marriage Act, I'll just briefly show those provisions. Just two or three provisions. I'm not getting it into in detail because that's not really the issue, but this is a good example to see how a court should approach these sorts of issues. And as I said, for example, judicial review cannot be excluded in cases like this. Because one, there is no practice. We've shown right across even India. Abroad, there's no question at all. There's no such practice. Everyone is allowed in. Everyone is, the children of both men and women are welcome. In India, children of women and men are welcome, but not women. But the women who are married out are nevertheless allowed entry in their own right. Now, this judgment said even they are not permitted. And we've shown the practice of the Bombay Parsi Panchayat, which is largely a trust holding housing and properties, but it also runs a religious agyari.
But the issue probably which you are raising, that may not be required to be responded on the, in terms of 25 or 26.
That's my lord is right.
I think section 19, 21 and 21A of the act itself answer in your question.
Will be very clear.
There is nothing more, nothing less required. I think once you read section 19, answer find there.
In fact, that is why I was originally not going to go into this, because this is not really strictly a part of the issues before my lords.
Your probably one of the simplest submission can be the majority opinion runs contrary to the statutory scheme of 19, 21 and 21A.
My lord is right. That's as simple as that. My lord is absolutely correct. And 25(1) as well. 14, 20.
25(1) is an issue need not be gone into because the statute 54
Yeah.
probably is well protected under
Well
25(2).
In fact, the statute, the objects and reason makes it very clear why it is brought in 1954 and the old Act of 1872 is gone. That persons of different faiths can get married. There is no provision in the statute which automatically converts anyone to any faith. So, two of the sections are referred to in this judgment. Section 13, marriage certificate is conclusive evidence. Nothing about whether that shows conclusivity on conversion. Gujarat High Court seems to have been impressed with that.
The statutory laws of religion, I'm using the word statutory laws of religion,
Yes.
only applies to Hindus and their allies, defined or expressly mentioned in 19. So therefore, if a marriage is solemnized under this act
Yes.
by a Parsi, by a Muslim or by a Christian, they do not lose their religious
My
status.
lord is right. And in fact, 19 has a severance of status from the joint family. So that's really in the context of a Hindu undivided family or a joint family, there is a severance of status.
In the context of that,
In the context of that, even that does not result in automatic conversion. Only a severance of status. That's all that 19 is. And in any case, as my lord has said, doesn't apply to any other religions. So, this is the sum and substance of the factual
so
case.
19 and 21, 21
Yes.
talks of succession, but 19 can have some impact on Hindus. That do they still be entitled to claim themselves? But that's a different debatable issue that
Yes.
can be looked into in some other proceedings. But as far as you are concerned, you are absolutely adequately protected,
Yes.
subject to what the other party will argue, under 19, read with 21 and 21.
My lord is right. Absolutely correct. So 19 squarely does not apply to Zoroastrians. But my lord, that ultimately will be in the matter. But therefore, this is the factual conspectus. Now, my lord, may I be permitted to advance a few submissions on the question
Yes.
before my lord? Lord, I filed a note of supplemental submissions. This is volume 2.4. Page 3 of volume 2.4. And I won't go through everything, obviously, because there are only some areas which I wish to emphasize before my lords. If my lords see page 5 of volume 2.4, Shirur Mutt broadly held,
The 3.4,
2.4, volume 2.4,
2.5.
2.4. At page 5, they start, page 3 and then 5 onwards. Because ultimately a balance will have to be struck by all lordships. That is the sum total of this exercise. And I think that is the sense I've got even from many of the submissions that I've heard from the first set of counsel. Shirur Mutt held, and I think that is right, that a religion has a doctrinal component and a practices component. You cannot divorce practices, rituals, ceremonies, etc. They are part of religion. And we are not for one moment suggesting that they are not. And in respect of the practices, Shirur Mutt used the expression which are regarded as integral parts of religion. And at page 5 at the bottom, Paris. Oh, I'm so sorry. I'm so sorry. You have hard copies. I have hard copies as well, madam. Give hard copy. Give it. Give it. I'm sorry, I didn't realize. These are with some judgments annexed, so they're not as bulky as might seem. No, that's all right. Now they're bound together.
Volume 2.4, is it?
2.4, but I have hard copies for your lordships also.
Which one you want to read? It is Shirur Mutt.
No. Supplementary.
Supplementary submissions.
Use 2.4.
Yes, they're on the screen. Yes, we can.
Additional submission, yes.
Sikh.
Shirur Mutt, that a religion would also include practices. And at 5.2, Ratilal Gandhi's case, in the context of Article 25, has said, every person has a fundamental right under our Constitution, not merely to entertain such religious belief as may be approved by his judgment or conscience, but to exhibit his belief and ideas in such overt acts as are enjoined or sanctioned by his religion, and further to propagate his religious views for the edification of others. And religious practices or performance of acts in pursuance of religious beliefs are as much part of religion, faith or belief in particular doctrines. That, I think that is far too well settled a principle for your lordships to even contemplate interference with. Now, there was a point of view expressed that Article 25 protects the individual's fundamental right to religious freedom, and 26 protects the denominational right. I would slightly, with respect, differ from that. My submission is, and that is supported by previous authority, that Article 25 is the source of the entirety of the fundamental right to freedom of religion, whether individual or collective. Because ultimately, an individual can worship on his own in the solitary,
Doesn't make a difference.
or he can go collectively to a temple or to a mosque and worship collectively. That's still part of his Article 25 right to freedom of religion. And both Shirur Mat and Ratilal Gandhi have held that. I've quoted them in paragraph 7. I've quoted the passages. And Ismail Faruqi's case also says that Article 25 guarantees equality in the matter of religion to all individuals and groups. So it's not that 25 is only individual, 26 is collective. In fact, there'll be several anomalies if that approach is adopted, which I have covered. Take, for example, 25(2)(b). It protects laws made for social reform or throwing open places of worship of Hindu religious institutions. If 25(1) did not cover institutions at all, then 25(2)(b) would make no sense. Even more, the right to freely profess, practice, and propagate religion is only in Article 25. Is it to be suggested that only an individual has that right and not a denomination? Because if 26 applies to denominational rights and 25 to individual, that would be the sequitur. But not so, because collective rights are also protected by Article 25. So 26 is really like a subset or a manifestation of an Article 25 right. Consider a situation where you had only Article 25. Article 26 was not in the Constitution at all. Could it ever be argued that individuals could not band together in groups or collections or denominations and exercise a right collectively? That would surely be within an Article 25 right. But if you take it the other way around, only Article 26, no Article 25, because if 26 is the source of all denominational rights, then it should be standalone. But if you take that, then could it be suggested that a religious denomination has no right to freely practice, profess, or propagate religion? Because it's not there in 26. So it can never be. The two are a compact. They have to be read together. And the source of the right, in my respectful submission, is Article 25. It covers individual and collective rights. Now, there will be a consequence to that, because the right of freedom of religion, if it is sourced to Article 25, then it comes with the limitations of Article 25. In other words, health, public order, morality, and subject to other provisions of this part. Could it be suggested that whereas the right to individual religion is subject to other provisions of this part, the right to denominational religion is not? I'm aware that 26 does not have that express language. But it doesn't have that express language precisely because it is sourced in 25. It's a compact. We have to read both together. It's the same right of religion. It's not a different right of religion that a denomination can manage. It's the same religion. And in fact, Mr. Subramaniam actually put it beautifully in his submissions. If I may permit to read from his submissions, he expressed what Article 25 was all about. And I'll just read that from his submissions. Para 53 of his submissions, I'll read it out. He explains Article 25(1) in beautiful terms. He says, it is respectfully submitted that this was to enable a mutual respect for the fundamental rights of others in the matter of exercise of the right to religious freedom, practice, and propagation. In other words, the fundamental rights of other citizens must not be injured. For instance, in exercising individual rights of religion, there must be forbearance from making defamatory expressions against other individuals or from attempting to undertake exclusionary practices on ground of caste. That is why the expression, quote, subject to the other provisions of this part, is included in Article 25(1). Thus, it is clear that for the purposes of Article 25(1), the principle of the right to exercise religious freedom as an individual entail peaceful coexistence and recognition of the rights of all other individuals in society. In other words, 25(1) is a repository of what I would think are ancient civilizational values of India, of tolerance, peaceful coexistence, and plurality. I may believe in one faith, but my belief and practice of that faith should not interfere with the belief and practice of another person who may believe in another faith. It's a very wise, it's a repository of a very ancient principle. As I said, we as a community are a fantastic example of that. We would not have survived in any other country. It is because of the tolerance and acceptance by Hinduism that we have survived for 1200 years. And 25(1) reflects that. But to restrict it only to individual practice of religion and to say somehow denominations are free from this would do great violence to the structure of 25 and 26. Because a denominational right ultimately is an individual's right. There's no separate entity that stands above an individual called a religious denomination, that even where an individual may not have the right, the denomination may have it. There's no hierarchy. None is found between 25, 26, 27, 28. These are the whole compact of protections.
So one other way of looking at it is 25(1) is subject to other provisions of this part,
Yes,
which will also include 26.
it would. But 26 draws its source from 25(1).
Yes, you have to.
26 without 25(1) is a meaningless right.
Problem which they are trying to put it to everybody is that you are trying to create a dead to 26. 26 nothing but an exemption of 25 in the sense
I'm obliged.
you practice, propagate things. It is only meant for that purpose. That's why 26 is individual.
I'm obliged.
As rightly said, it can't be negative equality. You can't say right is available, 26 not available, 25, 26, 25 2B is not applicable to. Their argument is, some other argument is that applicable to 26, but then applicable to their own members or individuals. Then what if you don't have a religious denomination, it will be applicable. If you form a religious denomination, if the argument is accepted, it may not be applicable. It can't be there.
My lord is right. I couldn't have put it better. It's not a binary. And why put 25 and 26 in
operates on
conflict?
a very limited scope. It's administered and managed. To that extent, the certain rights are independently given there. Those rights cannot be factored into 25.
But,
Otherwise, 25 is common for everybody.
but why, for example, 26B? Why is a religious denomination given the right in matters of religion to manage its own affairs? It's because its members have the right to freely practice, profess and propagate religion.
The difficulty is that when we started with Thirur Mutt, this attempt was made to synchronize both.
Yes.
If the argument was to the effect, no, this ultimately it is only a framework. 26 as a framework.
Yes.
Or a structure given under 25.
Correct.
A common belief, you put it there. Then
My lord is right.
then construct it like a building, then make it function. There's no difficulty. If you differentiate them, then your mind will be there to find something which is not there, and then
Correct.
connect it there, and then
Absolutely.
to make 26 to be 25 to be workable.
In fact, the test is C25(1) on its own. It can survive. But C26 on its own, can it survive without 25(1)?
Well, now,
Even without 26, it can survive. Denominations can
Yes.
survive.
Under 25(1), your ladyship is absolutely correct.
The framers of the constitution were conscious of the fact, even if you see Justice Mukherjee's judgment,
Yes.
he refers to the 4 mutts established by
Precisely.
Advaita, Ramanujacharya,
Correct.
Madhvacharya.
Madhvacharya.
See, they were conscious of how religion was being practiced in India through the mutts, denominations. That is why they brought about, being conscious of that, they have added that as a 26.
Your ladyship is absolutely correct.
It is to that extent.
The great Adi Shankaracharya,
Yes.
who institutionalized mutts as a denomination.
Yes.
what is very important is a mutt and a temple must not be confused. A temple is an institution which may be set up by a mutt,
Yes,
but it is not the same thing. A mutt is a religious denomination.
yes.
A temple on its own may not be. I'm saying may not be because it depends from case to case. I don't want to get into any specific case. It may or may not be. But certainly, ipso facto, a temple is not a religious denomination. It has to be shown to be a denomination where all the factors are.
It is more for what you call organized religion.
Yes.
Organized means where they propagate. Propagation takes place through what? Propagation takes place through mutts.
That is right.
And temples are also attached to mutts.
Correct.
It is in having regard to that aspect, this 26 has come about.
I'm obliged because, in fact, that's a very good example. If mutts propagate and they're set up for propagation, they can only source that right in 25(1).
Yes.
There's no independent right in 26. The moment you divorce the two,
To put it differently, you can, for a moment, we can forget about the mud. You can say that propagation is nothing but the propagation of the collective belief of the individuals under 25.
I bow.
It is, when you speak about a religious denomination, maybe mud or anything else, it is nothing but the collective individuals. In other way, to put it different, to take it to a very different proposition, the mud cannot act and go beyond the common belief or the collective the faith, because the very creation of mud is nothing but whatever the religious denomination is, a creation of 25 common belief. And with that common belief, you propagate through someone else, through some mechanism. It's an instrument to give effect to that belief.
My lord, please, right, precisely put. May I adopt that as my submission?
Putting it that
No,
with,
Mr.
with your lordship leave.
Mr.
Yeah.
Kapata,
Yes,
there may be a slight nuance to that.
yes.
It may not be that simple as you are projecting, because a denomination itself by its own may also have a different right than an individual. A denomination may be composed of individuals practicing a minimum common belief, but then it may have a special different right than compared to individual also. In that matter, every denominational right does not mean that it has to stem from 25. There is a finer nuance.
Let us test that. Your lordship is right. A religious denomination has the right in under A, 26A, to establish and maintain institutions.
Yes.
B, to manage its own affairs in matters of religion. C, to own and acquire movable, immovable property. And D, to administer such property, but that's in accordance with law. Now, your lordship is right that these are specific to religious denominations or sections thereof. No question about them. But the foundation of these rights has to be the right found in Article 25. Because if there was no right to freely practice, propagate, and profess a religion, then 26 would be utterly meaningless.
You are right. There is a continuity, but then there is also a disconnect. I'll give you a simple example. I am a believer in a particular deity or a god. Individually, I practice my religion as per my wishes. I may pray in my house or wherever as per how I desire. But then when we become a denomination, basic common belief is similar, deity is similar, fundamentals are similar. But then when a denomination is there, denomination will say no. Now, if you have to come and practice in this denominational temple, or
Yes.
then it may vary. So it cannot say that because I have a right to practice religion
Yes.
per se, I also have the right to practice in the way I as an individual will do that.
Your lordship
That is a dichotomy also.
I agree with that. May I explain what I'm saying? Denominations have some uniqueness or difference in character. In fact, Black's Law Dictionary says they are within a religion, but some different aspect.
They have a
So-
commonality.
They have within themselves a commonality, but there's a difference between how other sections or denominations of the same religion worship or practice. No doubt about it. I belong to a particular religious denomination, which has a particular practice which is different from how other members of the religion worship. But there are 2 points really to answer that. One is, of course, that if that religious denomination sets up an institution, it may be a temple, it may be a place of worship, Tower of Silence, whatever it is. If that setting up is under a document, a trust deed, then that trust deed has to be followed. Because especially in the Parsi community, most temples have been set up because someone has passed away, left a grant, an endowment, and that is in the form of a public charitable trust. So that denomination cannot say that though I'm set up under a public charitable trust, the particular beliefs of the then current administrators or trustees may be something else, so we can exclude. Because they are as bound by their trust deed as anybody else. That's point number one. Point number two is that even a religious denomination will have to establish that that practice is sincerely part of the doctrines of that religion. So I'm assuming if it is proven to be part of the doctrines of that religion, it's a different matter. And I also accept that where it is proven that this is part of the religious doctrine, at least for this section of the argument, a court may be very deferential to what the religion itself says is the religion. Of course, there are exceptions. For example, if there's not sufficient evidence, or if there are doctrinal differences within the denomination, that can also happen. Then a review is required. But if there is a unanimity and it is proven to be established beyond doubt that this is what the religion requires, then my lord is absolutely right. If it is part of that religious denomination, if the institution or the temple is set up only for that denomination and not generally for all members of the religion, then it's in a given case, it may be possible to say that if you want to come in, you come in as per the denomination's practices. So my lord is not wrong, but those are restricted cases. Most of the cases one will find are where the institution or temple is set up for the general benefit of the entire religion, not set up only for a specific denomination, and it's not proven as to what the exclusionary practices of that denomination are. Most cases are this gray area, which is why judicial review is an imperative.
No, that is why the words use are custom and practices also.
Correct.
Every word has a meaning.
But see
Doesn't
my
limit
case.
itself only to doctrine.
See my case. Far from establishing a practice, the overwhelming evidence shows there is no practice.
No, because you said it has wider ramification, that is why.
Yes, that's it. So in a
Not
given
in your
case,
particular case, it may be very
in
different.
a given case, I accept.
But because you already
In a given
give
case,
the picture that it has a wider paradigm,
my lord is
that
right.
is why the question was in the general perspective.
In a given case, it's if a religion is able to establish this is my religious practice,
Or custom also.
or custom, practice or custom, it is proven to the satisfaction of a court that it is. Then it is not for a court to sit in judgment over that. I accept that. There's no difficulty on that. That there has to be, because that's the balancing. But until one reaches that stage,
No, but even that will be subject to something which is not abhorrent, as just Nirman has used,
subject, of course,
to the conscience.
subject
It cannot be to that level.
public order,
Even if it
health,
is-
morality.
Whether it has been
And I will
centuries or
later,
not, whether
in
it.
my submissions also, there's now a fourth component, which is what I would call the R.C. Cooper line, which is that fundamental rights don't operate in a silo. So there may be competing fundamental rights under 14, 21, 15, which will have to be balanced, even against such a proven practice. That's a secondary stage. Today I'm at the stage where to even reach the threshold where one can claim a deference, the judicial review pulls back. Of course, nobody is saying judicial review is ever excluded. That your lordships will always have. But
In fact, what you are saying
yes,
is what's the ratio in Devadu?
my lord, this is
So
My
you
lord.
adopt the ratio of Devadu, that there should be an harmonizing
and harmonized.
of 26 as Devaru did with 25-2, it should be with 14, 19, 20.
Yes, my lord, in fact, that was an outlier, a very early judgment, where this principle of balancing and proportionality was first gone into, before R.C. Cooper even.
That's
Even
why-
before R.C. Cooper.
Sorry, I indicated.
Correct. My lord is absolutely right. So that thought has always been there in 25, 26. R.C. Cooper widened it to other fundamental rights also.
So in other words, it can also be said, 25(2)(b) will apply, 2B, 25
To be
will apply.
correct.
So long as there is no breach of Article 25(1).
Yes, my lord. Your
If
addition
there is
absolutely
no
correct.
breach of 25(1), 25(2)(b) can apply.
Yes. Yes.
And 25(1) will take within its fold 26(b) also,
Yes. Absolutely. Absolutely.
when it comes to a denomination.
When it comes to didn't
Mr. Khambata, on a lighter when
Perhaps
all the council have assisted us with regard to 25, 26, interplay there were. But the summing up submission is your lordship will have to balance. We need to have to balance.
I've tried to do that.
We are not given.
I've tried
And
exactly
when
to do that
everything
in my
is said, your
submission.
lordships have to balance.
I'll
How
come
to
to that.
balance that? Everybody
I have-
knows this is the interplay between 25.
I've spent a lot of time on that.
Be more
in my
focused on
submission.
that.
I'll be coming to that. It's in my submissions. I'll be taking you all through it. Because there's a theory of proportionality, double proportionality. How do you balance rights? There can't be a complete solution because ultimately it will be case to case.
Ultimately, it has to be some facts,
But there are mechanisms by which your lordships have devised.
some broader objective parameters.
I have covered that in my submission because my lord is right. Even I kept on hearing this. You must harmonize, you must balance. But that leaves your lordships in a bit of a quandary. There are guidances. Of course, your lordships would think of something else even. But today we already have some paths that guide us. If my lords come back now to another point, starting from para 11 of my submissions, there's another point which I want to make here. 25(1) itself speaks of an equality, even apart from 14. All persons are equally entitled. Now, that would mean that equality is textually embedded in 25(1) itself. We don't even need to go to 14. Now, what is that equality? The learned solicitor suggested it was to be restricted. But in my respectful submission, that equality can be of various types. And one cannot restrict the categories, but just what I've been able to think of, I put in para 14. Equality between individuals and other individuals. Gender equality. There's no reason why that shouldn't come in equality. Equality between religions. Equality between religious denominations and sections. Equality within a religion or within a denomination or section.
But would you extend it to equality between individual and a denomination?
There's no reason why not. There's no reason why. I accept that.
But won't we do violence to the provision of the words of 25, which says subject to other provisions of this?
In fact, I think what is happening is that has been the peg on which most of my learned friends have said, therefore 26 must have primacy. But that is not so. If one reads 25(1) and 26 together, if they are a compact, then one will not give primacy to one or the other. It has to be read together. And that is probably why the Constitution didn't again repeat the same words in 26. For example, they don't repeat the words that the denomination has the right to freely profess, practice, and propagate the religion. But does that mean a denomination does not? Of course it has that right. They don't have to. And therefore, the words subject to other provisions of this part are also not repeated in 26. It's the same principle. Therefore, you read them separately, there are all sorts of problems. But harmonize them and read them together. Because the religion that is spoken about in 25(1) is the same religion that 26b speaks of, matters of that same religion, not some religion outside 25(1). It's the same 25(1) religion. Otherwise, the argument would have to be that no, 26 is a standalone, it's an island. It speaks of some higher religious right, and our Constitution decided to give a denomination a higher right than any other group or individual or anyone as far as religion is concerned. I don't think that would be a fair reading of the two provisions. They have to be read together.
In order to see whether there is a breach of Article 25(1), what is stated in Article 26 would be of assistance.
Yes.
It is a route
It's one of the branches.
for to see whether there is a breach or not.
It sets out with some specificity.
They have a right to maintain, to have their own, manage their own affairs.
In matters of religion. Which religion? The same one is referred
Yes.
to in 25(1), not a different one, not a wider one or a narrower one. It's the same one. Take another example from
By
our
one of the judgments, the author has said, nothing more, nothing less.
nothing more, nothing.
Nothing more, nothing less is written.
It's the same.
One of
That's the balance.
judgments.
Now, here, let's take another example. Article 21 and 22. 21 is wide and all-encompassing. Your lordships have held so much comes in life and liberty and can be denied only by procedure in accordance with law. 22 specifically talks about protection against arrest without being told the charges, access to a lawyer, being produced before a magistrate. If 22 was not there, 21 would still cover it.
Yes.
It's not that you didn't have it, but 22 just makes that clearer. It's a manifestation.
It lays down the procedure
Procedure,
referred in 21.
21. Therefore,
But we see a significant departure in the words when we read 25(1)
yes.
and 26. The significant departure is what you said.
So,
The subjugation of 25(1) when it is individual or group,
yes,
and a special status to denomination when it comes to denominational right,
correct.
establish, maintain, and manage its religious affairs.
That is why, my lord is right.
Some degree of meaning to this dichotomy or apparent
Apparent,
status,
yes.
status difference.
correct.
Although all fundamental rights are equal, but some rights are more equal than others.
I'm leaving aside even the R.C. Cooper line. I'll come to that later.
Like-
Only on 25, 26.
The golden, the triangular right.
Yes. But
Madam,
let us see.
14, 19,
Yes.
21,
I'll come to that later as a separate compartment.
compelling rights.
My lord is right.
Would you put 25(1), even the freedom of conscience at that level when it is subject to other provisions of this part?
As,
But when it elevates itself
yes.
to a denominational right to manage and maintain its religious institutions, its
May I-
religious affairs,
May I respond to that?
crystallizes into something as co-equal.
Yes,
So we do the harmonizing test
yes.
of co-equal rights.
May I answer that on two planes? The second answer will be the R.C. Cooper line 14.
That is-
I'll come to that later.
By-
Let us assume we only have 25 and 26.
Mr. Kambata, now you are trying to persuade us is to go beyond Devaru and say that 25, 26 is on the same plane, and therefore 25 rights also have the preeminence as 26 rights.
May I put it a little differently?
The 26 is an articulation or a species of what is stated in or encompassed under 25(1).
That is correct. And 26, if it is read as not in any way fettered by 25(1) because of the absence of specific language, it may not be fettered if that view was taken, but then it also doesn't have the content of 25(1). Because the question that immediately arises is, if 26,
That will only come, as you rightly said, in very rare cases.
no, not, I know, no.
Individual 21 right of conscience of practicing religion comes in
No,
context.
my lord, with respect, no. Let's take a case where a religious denomination goes out and tries to propagate a religion. You have, I don't want to mention, certain institutions which do that. Now, can it be said that that is not a right available to the religious denomination because it's not there in 26?
Then it is exercising 25(1) rights.
That's
It
right.
is not exercising 25.
I am obliged. Therefore,
So, when you see 26 rights, it is restricted by its words, not in respect of its reference to 25(1). 26 rights are establish and maintain institution and manage its affairs, religious affairs. Now, if the institution in its management of religious affairs require a propagation on particular days or
Yes.
particular religious festivals, it can do it. And any hindrance to that will be protected on co-equality with other fundamental rights. But if
May I
an
put-
individual chooses to do it, which is not an institution, then we have to have a differential approach.
may I break up my answer, my lord, step by step? First is the word persons in 25(1) includes individuals and collectivities and groups of persons as well. It can't be restricted only to the individual. So a collectivity of persons who have similar beliefs can come together and say, we want to establish an institution so that we can collectively worship in that institution. Now, that right they have even under 25(1) itself. They can do it so long as they do not infringe the rights of any other group of believers or individuals to profess their religion. That fetter is there. It cannot be suggested with due respect that that fetter is removed only because now they call themselves a religious denomination and they say under 26B, there is no fetter of other provisions of this part. Because if they seek to source their right from 25(1) to freely profess, practice, and propagate, they take the right as it is under 25(1), not some different right. So if a religious denomination exercises collectively 25(1) rights, then those rights are subject to all the extensions and fetters that 25(1) gives to protect.
When they come under that umbrella of denominational right, whether individual part of that denominational right, can he say, I have a right of freedom under 25(1), I will not be bound by the right of.
No, that's not my argument. That's not my argument.
That is what.
No, that is what is troubling your lordships. I understand that. But let me try and meet it.
There will be an interface between an
Yes, there
individual
will be.
freedom of
There
conscience
will be.
and his right to profess
There will be.
and propagate that conscience.
So may I?
Against a denominational right, the denominational right has to be given its.
Yes, undoubtedly. But to reach that conclusion, a number of steps have to first be traveled.
I'll just expand this what may be.
Of course.
Can a member of a denomination question the religious practice which affects him? Despite him, in that case, will he be termed as continue to be a member of the denomination, or if he automatically goes out because he questions the practice and then belief. But
Yes, I understand.
though primarily he may agree. If he does it, as my brother did, can he trace it under 25(1)? Is right. Or could it be a common law remedy? Number 2. Number 3, what is the judicial review available? Number 3. Number 4, what could be the forum?
May I attempt?
Put your case here.
You're
Put your case in that.
That's right.
We all-
Let me try
Yes.
and frame it. Let me try and frame it.
Yes.
First, to give any play to the 26B right, as well settled, and I've covered this in my submissions, it must be proven that that is a bona fide and sincere custom or practice that the community or the denomination follows. That's not always easy. We are skipping those steps and we just go to the third step.
No,
But that's the first step.
for the moment, let us forget about 26.
Yes.
We take it that, as you rightly said, they are a common belief. They also get traced under 25(1).
Absolutely correct.
If they trace it under 25(1), there is, take your own case, no?
Yes.
25(1) they say, it may be right or wrong, we will not go into it. Only our testing it as a proposal. Now, as an individual, you are questioning it. Which means,
May I?
they institute the religious denomination, which we presume that it reflects the common belief or common practice.
If we presume that satisfies the test of Ratilal Gandhi and that early case of Jamshedji and Sonabai, it's genuinely held. 2, we presume that within the denomination there is no conflicting doctrine. It is established this is the only doctrine. If those 2 are out of the way, then yes, if an individual gets up and says, I say that this practice is wrong, I don't wish to follow it, then the only recourse that individual has, he has a twofold recourse. One is he must establish the practice is contrary to public order, health, or morality. Or he must set up a right under 14, 15, or 21 to say it conflicts with my right, at which point the balancing exercise of proportionality comes into play. That's how I would play. But if he is not able to do that, or if she is not able to do that, then my lord is absolutely right. You can't walk into a temple or a place of worship and say, I refuse, provided it is established that as a matter of doctrine, that is part of the religion. But that's a very, very important step which protects against 26B, which is really a protective, it protects against the state.
Difficulty
Their
comes
all
in,
cases
Sambata.
are against the state law.
It's against state.
It's a practice, there is a religion.
Because that is a protection against the state. It's not meant to be an instrument of domination over some individual's rights under 25(1).
These-
That's not the intention.
All these case law are with regard to state law,
Precisely.
where they are asserting their rights.
The
Therefore,
state says this is secular, we want to regulate it.
25(2)(b) law is questioned. It is basically a violation on the basis of a violation of Article 25(1),
Yes,
incidentally read with the assistance of 26(b),
I'm okay.
if they are a denomination.
And that
If
is,
they are not a denomination, 25(1), if it is violated also they can question.
and that is why I say that
Now,
the,
now we'll test your case.
A
now.
temple need not be belonging to any denomination.
yes,
It can be a standalone temple.
precisely,
Then
precisely.
we say that they have no rights, then.
For example, in my case,
Yes,
the trust deed says it's for all Zoroastrians. It doesn't say it's for only those who have not intermarried or only men who can intermarry can come in. It has no such restriction. It's for all Zoroastrians. So it can be said by the present, and this practice has changed over the years. It can be that the current set of trustees or administrators impose their own personal view on something. It can be. So there's no practice there. There's no
So
proven
we
practice.
take it, if if you are questioning the decision being contrary to the practice, that's a different thing. If you are questioning the practice itself, then can you trace it into 25?
I'm questioning that there is a practice,
That's what, that's
a
it.
proven practice.
Then the next question will be what is the extent of our judicial review and which forum you can.
Correct. In fact, towards the end of my submissions, I have chosen to try and suggest which are the areas of judicial review and which are not.
Yeah, so
I have-
your argument is that there's no practice at all, it is only a decision made by them.
Correct. And if that is so,
To
then
that
it
extent,
can't be
makes
that
it
they
very
say
clear.
that because we, the current administrators, say it's a practice, that a court backs off. It can't be. Court has to exercise its judicial review. Or if they are not able to show religious doctrine, that here it is. In fact, in this case, all the religious doctrine is to the contrary. In my respectful submission, I may be wrong. That's a matter for the court ultimately to decide. In fact, we've carried out the exercise. There are some 5 verses that are relied on. Ex facie, each of them don't bear out what they say they do in the submissions. Ex facie. So easy. But that's not for your lordship. But that element of judicial review has to be retained. Otherwise, people will misuse the protection given under 26(b) to turn it into some instrument of domination or supremacy over 25(1), which is not the intention under the Constitution. The word subject to other provisions of this part does not entitle 26(b) to be elevated into some pedestal. That is not the intention of the framers.
that is why in Venkatramana Devaru, they said that harmonizing.
Harmonized.
must be there.
It has to be there. In fact, one way or the other, giving supremacy will be the annihilation of religion. If one is given such supremacy over the other, in fact, one of my learned friends has used very strong language, maximal effect, disciplining. These sort of words are not what 26(b) is all about. 26(b) is to prevent state interference.
Yes.
To manage your own, not to use it as an instrument against your own denomination members.
To my knowledge, the word religious affair would only mean with respect to, there are 2 roles which religious denomination should follow.
Lordship.
One is with his activities other than the members of the denomination. The other is with respect to the how to regulate it within the denomination. It has got, insofar as the religious practice per se is concerned,
Yes.
it by itself, it cannot evolve.
Take another issue.
Or it cannot create one. It can only be by the common belief.
Take another issue.
Yes.
Equality is embedded in 25(1). Now, that could be, as my Lord Justice said, an equality between an individual and a denomination. Also, I'm not precluding any such so-called contests. That's right. Therefore,
That is unnecessary. Even if you take it between one individual and a group of individuals.
the group of
You
individuals.
can name a denomination.
Each one will have to be balanced.
Whatever the name, that's
Each
irrelevant.
one- If, for example, the group or the denomination
Yes.
insists on what appears to be a trivial practice, which is not doctrinally established, and there is a total exclusion of the believer on basis of that, a court might say no, because you're obliterating the 25(1) right on something that's not really a matter of religion. In that connection, I must tell your lordships that do I agree that essentiality test has caused problems. But when it comes to balancing
Yes,
and proportionality, there's no other way At least I have not been able to think of any other, but I'll show that when I come to that section. But one will have to see what is integral or essential. Otherwise, it's impossible to balance.
It may not be a test, it can be an aid.
It can be an aid. Now, even morality, I'm not, this phrase constitutional morality, I'm leaving aside. That's not the phrase. Morality, what does morality mean? The mores of the day.
Yes.
But the mores of the day in a constitutional democracy, one of the factors will be the constitution. For example, can one not say that casteism is immoral? Or treating a woman as a chattel of her husband is immoral? That will also arise. We don't have to go to 14, 21 to even get there. So morality has a broader meaning. It may not be this constitutional morality concept. With respect, I have not understood.
Correct. Although they also argue it's a combination of
It has to be.
various parts under the
That's
constitution.
right.
Yes, that's all.
And equality is built into 25(1). It cannot be taken away by 26(b) saying, but you are subject to me. Because equally you are subject to 14. So how will that balancing take place? So equality is embedded in 25(1). It can't be rewritten out of 25(1) merely by saying because it's subject to other provisions of this part. Now that brings me to a smaller area, which is what is a denomination? And my learned friends have addressed at great length. Now, there are various meanings. I've covered them from paras 16 onwards in my note. I'm not going to read all of those, but broadly speaking, a view was evinced that the SP Mittal test may be too restrictive. Because SP Mittal, as your lordships recall, there has to be a collectivity of faith or belief. There has to be a distinctive name and there has to be a common organization. And it was felt a common organization is too restrictive. Various examples were given. Now, I don't think we should be so pedantic about this. An organization is some form of togetherness, structure, or administration. It doesn't have to have an office with a registered office. It need not be that. As long as there's some commonality of structure or administration, that would suffice to say that's the organization. And that's a more expansive and a better way of seeing it rather than
Say SP metal is only illustrative.
it's only. Therefore, the threefold test in SP Mittal, I don't think is something that it is, I think, a salutary test, but I would actually add a fourth criteria, which maybe sub silentio is there, but we don't say it, which is that religious denomination must have some uniqueness about it. If that denomination is not unique, then it's as good as any other part of the religion. How does it become a religious denomination? And clearly, an entire religion cannot be a religious denomination, because otherwise, why does the Constitution use two separate words? Religious denomination. So the whole religion can't be a religious denomination. In fact, that would lead again to innumerable problems.
What you are saying also will lead a lot of problem. How do you define unique? The uniqueness.
No, a different
In
practice.
Hinduism,
For
it
example,
is
there's so many.
impossible to create a uniqueness there.
No, in fact, as well, learned solicitor said, Hinduism is far from being homogeneous.
And then the
It's got
problem,
so many different facets and sections.
it'll have a bearing on your arguments on 25 also.
Yes.
If
No.
you say the object is to give effect to 25 and 26 nothing but 25, then if you say uniqueness, then it will give a problem.
No, within denomination.
I'll tell you why.
Huh.
10 people common belief, they can form a denomination. Another 10 they can common belief, more or less same belief they can form a denomination. Is it possible or not?
No,
See,
we
who are we to say, who are we to define and say about the denomination? Because it is object is to give effect to Article 25(1), which what is, so long as the common belief is there and they do it for the purpose of to practice and propagate. This sort of a definition, yes.
may I endeavor, my lord?
And then either adding or subtracting will be.
No, may I
sometimes
endeavor?
it's a disaster.
I understand what falls from my lord, but may I endeavor to meet them? We are not talking about private temples, even private from a group. A group can set up a private temple. We are not talking about those. We are talking about public places.
Character.
Now,
That's correct.
now a public character.
The only thing is it becomes amenable only if it becomes a public character. With that extent, they agree with you. No problem.
If you have a religious denomination with a public character temple open to all Hindus, then there is no specific unique denomination to which entry to that temple is restricted. But entirely accept that a denomination may have a unique practice, a different practice. Then if that practice is proven, established, of course, it gets some protection. No question about that, especially from state action. Unless the state has to resort to social reform. That's a different aspect. Or to public order, health, morality. But otherwise, yes. So you can have different denominations, but provided there is some uniqueness about them, otherwise they're not a denomination. They're the same as anyone else. And then what you're really doing is fragmenting, because then every individual can be a denomination. That is not the intention. So a collectivity can get together and say, we believe in this form of practice or worship. This is us as a denomination, and we establish it from the scriptures, from the ancient texts of sages. Here it is, it's always been done. It is established. That is correct. That will be protected under 26B. But an entire religion can't be, because that is the whole purpose of 26B goes. Then you're setting up a religion against an individual who believes in that religion.
It is
It can't
more
be.
in the context of propagation
Correct.
and how propagation of religion was done in India.
Yes.
We can say to some extent it was done through the
But
mutts.
through the mutts.
We'll be
Through the
citing,
mutts.
That is how Adi Shankaracharya actually,
Protected.
we'll be citing down.
India was heavily Buddhist. It became
See, the
back to
management
its ancient religions.
matters of religion means propagation of religion
Correct.
you can do through these organizations.
And that is protected.
That is protected.
And that is protected. No question.
Practice.
And no court can sit in judgment
Yes.
over that established proven practice. I accept that. But it's some way to say it's an established proven part of the religion.
We are only telling your anxiety is that whether it is a religious denomination or not, see, what extent should the court go into that? Or that whether that in terms of Article 25 and 26, whether it is the exclusive decision of the believers, common belief. If so, what is
That is also, my lord is right.
personally, I was
Very well
to
said.
believe we should leave it to the believers themselves.
Yes, of course, provided.
We have no role in this.
No, absolutely. My lord is absolutely right. But there are two important caveats I would add to that.
Yes.
If the believers can show that uniformly, or
That's right.
by and large, that has been the conscious, sincere belief of that denomination and supported by the religious doctrine. It can't be that those who are in control of an institution of the denomination for the moment suddenly decide that this is the religious doctrine. Then the court is entitled to see, is it part of the religious doctrine? Is it supported? If yes, then we will not sit in judgment.
You understood that?
That
With religion or not.
correct.
That's correct.
That's
Or it is something which can be severed.
can be severed. Now, in Devaru's case, there was a balancing between 25 2B and 26. And that was the first time that this balancing had happened. And that case turned on the fact that there was a partial exclusion, not a complete exclusion. That was the balancing done, that you're not totally excluding the rights of worshippers. They're not entitled to attend certain ceremonies.
In fact, I would read Devaru as showing the distinction between 26 and 25.
Yes.
If it were a mirror of 25, then Devaru would not have gone for harmonizing, but say that the state has all rights to override
No, I'm sorry.
matters of.
No, I'm sorry, I didn't make
But-
myself clear.
But
I didn't mean 25-2. 25-1. 25-1 and 26 are a compact. I should make that. 25-2 stands on its own. My lord is absolutely correct. Therefore, it was required in there.
that is why the harmonizing.
That is right. Therefore, the harmonization. But 25-1 is the source of 26. It can't be dichotomized or divorced from it. And a river cannot rise higher than its source. So 26 right cannot rise higher than a 25-1 right. That's all I'm saying. That's all. Now,
Rather 26 right is there because of 25.
25. It can't acquire supremacy over 25-1. And certainly cannot be given maximal effect and a right to discipline 25-1. These are some of the words that are.
The next point, I think.
Yes, I'll go to the next. Now, my lord, one small point which I won't go into it, just a correction. Mr. Subramaniam had argued that Ratilal Gandhi's case held that the Parsi community constitutes a religious denomination. No, that's not what it holds. It speaks of the Parsi religion. That's a loose term, as I've explained. Parsi is not a religion at all. It's a race or a community. So it meant the Zoroastrian religion. That's all it meant. It didn't mean to hold that Parsi Zoroastrians are a religion. I just wanted to correct that. I put that in my note. That's a small point. Now, if 26 is dependent on 25, and I've set out all the cases and passage from Sirvai, for example, my lords would kindly turn to para 36 of my submissions, just above para 37. So, instructive passage from Sirvai. It's at internal page 10 of my submissions. Sirvai says, 12.100, it is obvious that religion has both a personal and an institutional side. No doubt men can pray in their homes and hit heaven with their prayers. But throughout the ages, men have worshipped in temples, churches, mosques, and the like. In practice, the personal right is inseparable from the institutional. And a person would justly complain that he had been denied the freedom of religion if the right of private worship was conceded, but the right of public worship was denied to him. Articles 25 to 28 recognize this twofold aspect of religion. Subject to public order, morality, and health, 25.1 confers on every person the right to freely profess, practice, and propagate religion. But 25.2 expressly refers to the throwing open of Hindu religious institutions, etc. And then 12.93 at the bottom. Article 25 protects freedom of religion, opinion, as well as acts done in pursuance of religious beliefs. Rituals, ceremonies, and religious practices, according to the religious tenets of a denomination, are matters of religion within the meaning of 26b. So he also recognizes that the right to freedom of religion has a personal side inseparable from the institutional. So you can't separate 26 and say somehow that is higher than the personal. Now, both the learned solicitor and the learned additional solicitor put it very nicely in their submissions. And I have quoted them on the next page. May I just read out these two passages? Because I think that really puts it very nicely. First, the learned solicitor in para 72 of his submission says, in India, Articles 25 and 26 exist in a relationship of constitutional equilibrium. Article 25 protects individual freedom of conscience and religious practice. Article 26 protects the collective autonomy of religious denominations to manage their internal affairs. The framers gave both provisions the status of fundamental rights and did not say that Article 25 overrides 26 or that individual rights take precedent over collective rights. They said that both must be protected, and the constitutional task is one of harmonious reconciliation, not hierarchical priority. And the learned additional Solicitor General. An individual rights dominate approach may dilute denominational autonomy, reducing Article 26 to a residual guarantee. A denominational autonomy dominant approach may suppress individual freedoms within religious communities or undermining Article 25. Any interpretation that puts one right over the other risks constitutional imbalance. The Constitution does not contemplate such a binary. Instead, it envisages coexistence through calibrated reconciliation. In other words, the rights of individual freedom of conscience and religious practice under Article 25 and the collective autonomy of religious denominations under 26 are two sides of the same coin bound by the concept of religion. As such, the two articles cannot be read in isolation, but have to be read together to give meaning and effect to the protection guaranteed. Now, this is the balance that we are seeking. And it's not an easy balance. I accept that. But we're trying to assist your lordships in coming to this balance. Now, if your lordships, paras 40, 41, I've argued that if you take out Article 25, nothing is left in 26. But if you take out 26, 25 will still cover most of the rights in 26. Now, even assuming that 26 is some separate right, clearly in the scheme, it is complementary to 25, at very least. Even if the source is not 25.1, it's complementary to. It cannot operate in conflict with 25. And therefore, the right to religion, I come back to this, is 25.1. 26 cannot be read as a higher right to religion or a lower right to religion. It's the same right to religion.
These are two independent rights.
They are complement. And therefore, there is no hierarchy. Now, I've at page 13, internal page 13, I've cited some submissions made by one of my learned friends, which I believe are a bit extreme and will completely alter this balance. At para 45, I've set out the submissions which say that a religious denomination or institution of a public character stands for a collective representation of believers. Once a person is a member of a denomination, the individual right under 25(1) is manifested by a member of the organization being a believer in the denominational creed. It follows that the person would be subject to the discipline and tenets, as well as any supervision or oversight exercised by authorities chosen in that denomination. Both 26A and 26B, being untrammeled by any further limitations, are entitled to be given maximal freedom and respect. With respect, no. 25 and 26 are a compact. There are an equilibrium between them. The right to freedom of religion in 25(1). 26A and B cannot be given this sort of overriding effect over 25(1) because the raison d'etre of 26 is 25(1). You take away 25(1), there's no meaning to 26, even if it's complementary and standalone. Therefore, this sort of hierarchical priority, in my respectful submission, is not the correct way to go. It will lead to major problems. Now, why is this submission incorrect? With respect for my learned friend who I have the greatest respect for. But it's incorrect for this reason. First, your lordships have heard these principles of harmonization and balancing. Constantly, most of my learned friends have spoken about that. Indeed, my learned senior who made these submissions also in his same set of submissions said, in this sense, a harmonious reading of 25 and 26 would entail preserving denominational autonomy in matters of religion while giving effect to Article 25(2)(b), where exclusion from public temples is sought to be removed. Harmonization is not the subordination of Article 26 to 25, but a reconciliation of two co-equal guarantees to give effect to both. I am not able to harmonize his earlier submission with this one. I support the second submission of reconciliation of two co-equal guarantees and give effect to both. And then para 53 of his submissions, which I read out, that the purpose of 25(1) is to enable a mutual respect. Is it to even be suggested that this mutual respect and balance is given a go-by to once you're dealing with a religious denomination? That they have absolute untrammeled powers, whereas as individuals, you have to give a mutual respect. It can't be. The source is 25(1). In fact, to give such primacy to 26B will be to highlight the right to freedom of religion. Because then a group of people temporarily or in control of certain institutions will exercise a dominance, which is not the constitutional framework at all. It's a balancing. That group can enforce religious doctrine if they establish it. They can enforce it if the community sincerely believes in that religious doctrine and it's an unbroken practice. But they cannot just impose based on what they perceive to be some religious doctrine or practice, suddenly impose an exclusionary principle. That they would have to go to a civil court and establish before they can exclude. Therefore, in my respectful submission, this is the balance between 25 and 26. Now, page 18, internal page 15, I come to a different aspect of my argument. This is now not only a balancing between 25 and 26 that your lordships will be required to do on a case-to-case basis. There is now also a balancing between 25, 26 and other fundamental rights, 14, 21, etc., 15. And that, of course, is the famous decision in R.C. Cooper's case, which says part 3 weaves a pattern of guarantees. You can't just say one is higher than the other, or it's a pattern. They all have to be interpreted. The passages from Menka Gandhi, which explain R.C. Cooper, are also very instructive, which I've set out in para 51. And may I just read from the bottom of page, internal page 15, articles dealing, para 51 of my submissions,
51.
at
Yes.
internal page 15.
Yes, please.
It's actually running page 18 in the volume.
Yes.
The bottom passage from Menka Gandhi, articles dealing with different fundamental rights contained in part 3 of the Constitution do not represent entirely separate streams of rights which do not mingle at many points. They are all parts of an integrated scheme in the Constitution. their waters must mix to constitute that grand flow of unimpeded and impartial justice, social, economic, and political freedom, not only of thought expression, belief, faith, and worship, but also of association, movement, etc. And then page over, of equality and of fraternity. Isolation of various aspects of human freedom for the purpose of their protection is neither realistic nor beneficial, but would defeat the very objects of such protection. So isolating 26, in fact, the learned solicitor also said it's not an island, it's not standalone. Isolating it, and worse, giving it some supremacy which the Constitution doesn't give, will ride a coach and four through the whole balance and equilibrium of 25 and 26. And then, of course, this was followed also in the privacy case in Puttaswamy, and where it was held no element can be read in a manner disjunctive from the composite whole. Small Roman 4 at page 16, I have cited from Adi Saiva's judgment, where your lordships held the freedom of religion being subject to other provisions of part 3, undoubtedly 25 and 26 of the Constitution has to be harmoniously construed with the other provisions contained in part 3. And even Sirvai says that it's part of a scheme which embodies valuable human rights broadly called civil liberties conferred by 14, 17, 19 to 22, 23, 25 to 28, religious freedom, etc. So even when you take this line, balancing with other rights in part 3, R.C. Cooper did not require an express provision to say subject to other provisions in part 3. You take 26 alone, it is subject to a balancing with competing or conflicting fundamental rights under 14, 15, 21. You don't need the words, because R.C. Cooper, Menka Gandhi, and Puttaswamy have said that that balancing has to take place in any case. And we must keep in our minds that 26B is really a protection against state action.
Yes.
It's not meant to then lord it over your members. That's not the idea of 26B. And so learned solicitor has also said 26B cannot be read as an independent silo, and 25 and 26 must exist in a state of constitutional equilibrium. Now, your lordships rightly put to me, we are being told this, how do we balance? These learned solicitor, and I haven't put this in my note, but I'll just give the relevant para numbers. At para 134 small d of his submissions, volume 1.5 at page 39, has said this: if competing constitutional rights are invoked through state action, resolve the conflict through a structured optimization exercise, including proportionality, and not by presuming that one right extinguishes the other. So
Where is it?
he had said this in para 134 small d, volume 1.5 of his written submissions. Volume 1.5, page 13. That's right, I agree with this. But I'm going to explore this further. How is it actually done in practice? What is the way to do it? Now, let's first see what are the other fundamental rights that we are talking about. What do we have to balance? So, if my lords kindly turn to internal page 18 of my submissions. First, as set out and held by the judgment in Joseph Shine's case, which laid out the fundamental principle that today marriage is a partnership of equals. A wife is no longer a husband's chattel. And treating a woman as chattel is manifestly arbitrary, interdicted by Article 14 and amounts to discrimination under Article 15. And marriage, whether it is a sacrament or a contract, does not result in ceding of the autonomy of one spouse to another. So a man and a woman have to be treated with equality. Marriage doesn't alter that. That whole notion of treating a woman as a chattel is immoral. It would go even on that ground, apart from being in complete violation of 14 and 21. Para 57 of my submissions, I refer to the judgment which your ladyship mentioned in Association of Old Settlers of Sikkim, where under the Income Tax Act, the income derived by a Sikkimese individual from any source within Sikkim was exempted, but that exemption was given only to a Sikkimese man, not to a Sikkimese woman who married a non-Sikkimese. That was struck down rightly by your lordships as being completely violative of 14, 15, and 21, and completely discriminatory. Now, therefore, I'm not saying that if some religion manages to prove to the hilt with doctrine that some aspect of it is completely discriminatory, that your lordships will review that discrimination. But your lordships can certainly and must balance that religious practice, must see whether it is an integral part of that religion as against the rights that it takes away under 14, 15, and 21. That is an exercise a court has to do. It can't be that a religion says, even a proven practice, because this doesn't apply in my case, but I'm saying, assuming it's a proven practice, it's part of our religion. And never mind 14, 15, 21. That can't be. And I dare say, I'm not an expert on religion, but I dare say, I am not familiar with any religion that as an integral part of the religion subjugates women or treats them as chattel. As an integral part. It may have been some practices evolved over time, but they're not an integral part of any religion today. So the resistance to review of what is an integral part, an essential part of a religion, perhaps stems from the fact that most of these practices, which are pernicious and immoral under our constitution, would not fall within the integral part of any religion. I'm not on any specific case. I'm not on the Sabrimala case. I'm not on any. I'm just generally saying.
So you are saying that yeah, the religious practice will have to be tested through a secular eye.
It will have to be tested under our constitution. Is it moral under our constitution? For example, what if a religious practice is casteist? Will it not have to be tested? Exclusion based on caste. Now, there I know we are covered by a specific provision of the constitution, but assuming that was not.
Religious practice at all.
Yes,
See, a religion,
correct.
religious practice will not extend to exclusion of certain castes.
Yes,
That is not religion. Neither is it religious practice.
that is the only exercise.
Article 14 really does not enter the space of Article 25(1). The reason being, Article 14 says the state shall not deny any person equality before the law or equal protection of the law. That is, the state should. Here, Article 25(1), it's not really against the state. It is recognizing an inalienable right of freedom of conscience, but subject to these riders.
Yes,
Because we have a written constitution, we are in the 1950s, we have a written constitution, therefore it says, therefore 14 principle does not really enter 25(1) at all.
correct. Because 25(1) itself refers to equality. It doesn't need 14
Particular quality principle in itself.
in itself. I'm okay.
So if there is any religious practice which excludes a class or a section, then in that context, Article 25(2)(b) will enable the state to make a law.
So
That is
even,
why we said essential
Kapata.
religious practice is only an aid.
even in
It's
a
an
case,
aid. It's an aid. It is an aid.
even in a case like, there are two, Guruvayur temple.
Yes.
They close the temple for 4 or 5 times. There'll be heavy rush. It is controlled by the state. Now, can they say, no, you stop these religious practices, sir?
Because
We are
that,
bringing a
that is right. That's a
legislation.
good example because that doesn't totally exclude the right of the worshippers. It's a partial exclusion like Devaru's case.
Partial
Therefore, you can balance.
exclusion. That partial exclusion.
That can
is
be balanced.
permissible, even according to you.
Partial
Partial
exclusion,
restriction is permissible.
if it is an integral part of the religion, yes.
Oh.
If it is an integral part, that's a big.
It's a
if.
part of religious practice, let us say. Let us not.
Proven doctrinal religious
Or
practice.
non-integral. It is a part of
Well,
religious
integral-
practice.
Has never been mentioned under the constitution yet. How do we
I'll tell you.
use the
I'll come
word
to that.
which is not available? and
I'll
not
come to
available?
that. I'll come to that tomorrow because
Yeah.
that is
No
part of
problem.
proportionality.
No problem.
Without seeing what is the core interest of every fundamental right, you cannot balance. That-
Suppose, we'll give a very stark example. If they say at the time in a temple, at the time of bhog or offering, persons belonging to depressed classes cannot be present. That can be resisted. State can bring a law.
Yes.
That is social exclusion. But if they say, when there is an offering of bhog or to the food to the Lord, the curtain will be closed or the
Yes.
door will be closed and nobody should see it. That is part of religious practice. There is a vital difference between the.
Therefore, it's a case by case assessment. It has to
You
be.
can't say it's a religious practice, I will exclude certain section of Hindus.
For
Or
example,
a certain.
in
That's why
Zoroastrianism,
Venkatramana Devaru, they balanced it.
in Zoroastrianism, neither men nor women, nobody can enter the sanctum sanctorum, only priests.
Practice, we have to first identify.
Nobody can enter.
And the court or the state cannot say this is not a religious practice if it is intimately connected with the doctrine.
Yes, yes.
Yes.
I'm obliged. May I continue tomorrow? But I won't take long.
Approximate how much time?
I think I have about
Of course, without our interruption.
no, with about half an hour to 45 minutes. I think I'll go long.
You can't